dispensed with. The Benny is directed to take notice for R3. Senate counsel for the appellant to furnish one set of appeal papers to Sri Ravish Benny. Forthwith. Plain Ilala. Admit TCR. Next. Memo accepted. Notice to R1 dispensed with. Mr. Benny, 402 days. Denial of. Denial of interest for 402 days. Usually 402 days. Learned counsel for the appellant is absent. No representation. Appeal dismissed for non-prosecution. Hearing on AF, number 23, PC Karnataka. 1 of 2022 is dismissed. 1 of, what is this?
29.
Why it was dismissed? This is enhancement appeal. Enhancement. IA 1 of 2021. I will recall the order subject to denial of interest. IA 1 of 2021 is this appeal claimants. This is a before that. This is a claimant's appeal calling in question the judgment and award passed by the learned MACT dismissing the claim petition. IA 1 of 2021 is filed for recalling the order dated 15/6/2021 and 2/7/2021 dismissing the appeal for non-prosecution. Dismissing the appeal as against respondent number 1, who is the owner of the offending vehicle. For the reasons stated in the affidavit, the order dated 15/6/2021 and
R1 and R2 ಎರಡು recollect. Respondent 1 order ಅಲ್ಲಿ 15/6 ಅಲ್ಲಿ R1 ಗೆ 2/7 ಅಲ್ಲಿ R2 ಗೆ.
An application seeking recall of the order dated 15/6/2021 dismissing the appeal as against R1 and order dated 2/7/2021 dismissing the appeal as against R2. For the reasons stated in the affidavit, IA 1 of 2021 is allowed by denying interest on the award amount.
Only 6 days. Notice delay ಮೇಲೆ ಹೋಗಿದೆ 6 days delay ಅಷ್ಟೇ. But steps ತಗೊಂಡಿಲ್ಲ ಅಂತ PF ಕೊಟ್ಟಿಲ್ಲ ಅಂತ R1 and
filing the appeal there is delay
6 days.
Why so?
From the date of filing of the petition, ಎಲ್ಲ delay negligence is. Summe insurance company interest ಕೊಡಬೇಕು. From the date of the impugned judgment and award, denying interest from the date of the impugned judgment and award till today. Mr. 6 days delay I will condone. IA adestadu IA 1 of 17 is filed for condonation. 2015 appeal 1 of 17 agade.
Office subject sir.
ಆಯ್ತು.
IA ಫೈಲ್ ಮಾಡಿರ್ಲಿಲ್ಲ 17 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಡಿಲೇಗೆ.
IA 1 of 17 is for condonation of delay of 5 days in preparing the appeal. It is to be noticed that at the time of filing the appeal, even though there was some delay, no application seeking condonation of delay was filed. And after the office raised this objection, my application seeking condonation of delay was filed in the year 2017, namely IA number 1 of 2017. For the reasons stated in the affidavit, the delay is condoned subject to denial of interest as aforesaid. Already now admit if you are notice in R1 issue notice to R1 admit PCR. ಅದು ಆಯ್ತು ಆಗ್ಲೇ ಆಯ್ತು ಆರ್ಡರ್. ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರೇಷನ್ ಈಗ ಏನಪ್ಪ 1 of 19 ಆವಾಗ ಹಾಕಿ ಮೂವೇ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್.
Yes, my lord, I sought for
You
paper
have sought all
publication.
right 1 of 2019 and you have not moved at all. After 3 years it is coming.
I have one of. I have, my lord, it is not posted, my lord, and I have filed it in
Oh,
the
right.
office.
Right. Okay. You don't have to do anything.
Yes.
You go on paying interest. Fine.
What to do, my lord? Office is not.
Yes.
I sought for substituted service for.
R4 alla. IA number
R4,
1 of 2019 is allowed for the reasons stated in the affidavit. Dates alla website ನಲ್ಲಿ ನೋಡಿಬಿಡಿ, steps ತಗೊಂಡ್ಬಿಡಿ.
Before publication date, my lord.
ಅರೆ ಅದು ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಸಿಗತ್ತೆ ನಿಮ್ಗೆ, ಹಾಕ್ತಾರೆ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ. ನಾನು ಇಲ್ಲಿ ಇನ್ನು ಅದಕ್ಕೆ ಟೈಮ್ ಯಾಕೆ ಸ್ಪೆಂಡ್ ಮಾಡೋದು, ನಿಮ್ಗೆ ಸಿಗತ್ತೆ. 2 weeks time granted as a last chance for taking steps to R1. ತಗೊಂಡ್ಬಿಡಿ.
I am appearing for the respondent, my lord.
315 days.
Delay condone ಮಾಡ್ಬೋದು sir.
IA
Without
1 of 20 for condonation of delay of 315 days in filing the appeal for the reasons stated, and will be subject to denial of interest for 315 days. Admit TCR.
Please.
1 of 17 ಇದು denial ಇಲ್ಲ, condoned. Admit TCR. ಆಯ್ತು. 1 of 17 ಇವ್ರೆ ಇದು ಕಂಡೋನ್, ಇದ್ರಲ್ಲಿ ಏನು ಡಿನೈಲ್ ಏನಿಲ್ಲ, 100 ಲೆಸ್ ಇದೆ. ಅಡ್ಮಿಟ್ TCR ಇದರಲ್ಲೂ ಅದೇ 60 days ಕಂಡೋನ್, ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನಿಲ್ಲ. ಅಡ್ಮಿಟ್ TCR. ಈ R1 to R3 ಏನು ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಡಿಫರೆನ್ಸ್ ಇದ್ದಾಗಿದೆ.
ಅಪಲೆಂಟ್ ಇನ್ ಸರಿಯಲ್ಲ ಮಾಡಿ 20.
1 of 17 37 days delay condone, denial interest ಅದೆಲ್ಲ ಏನಿಲ್ಲ. Admit TCR
37 days delay.
97 days 30 29 is over 30.
30, my lord. Delay may be condoned
17
without
is
interest
allowed.
and must be posted for admission, my lord.
Denial ಏನಿಲ್ಲ. Admit TCR.
Delay may come in condoned, my lord.
ಸರಿ ಸರ್, ಸರಿ.
Please, please.
70 days denial ಏನಿಲ್ಲ.
29 37 days delay.
ಆಯ್ತು, ಅದೆಲ್ಲ ಮುಗೀತು. ಈಗ 32 ಇನಾಗಿದೆ. ನೋಟಿಸ್ heard on IA number 2 of 2021. ನೀವು ಫಸ್ಟ್ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ ಅದೇ ಫಸ್ಟ್ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ. ಹರಡೆ ಏನ್ ಬೇಡ. Learned counsel for the appellant is present. He is directed to comply with the office objections within a week's time, least after compliance.
33, Rajaram member.
IA 1 of 2022 is rejected. Appeal admit ಆಗಿದೆಯಲ್ಲ. Post for hearing as per seniority. Call for TCR ಬಂದಿದೆಯಲ್ಲ. ಏನ್ ಬೇಡ.
34, Mr. Dabali.
Have you deposited, Mr. Dabali? You have deposited. Learned counsel for the appellant insurance company submits that. Again, acknowledgement. Submits that the amount submits that 50% of the award amount has already been deposited before Learned MACT. ಏನದು
ಹಾಕಿದೀನಿ ಅಂತ.
On 31/1/2020 by way of pay order drawn on syndicate bank. 14 days delay will condone. IA 1 of 18 ಇದರಲ್ಲಿ ಏನು ಡಿನೈಲ್ ಏನಿಲ್ಲ. Condone, admit TCR. ಅಷ್ಟೇನಾ? ಮತ್ತೆ ಇದ್ಯಾರು ಇದು R1 ಅಂದ್ರೆ ಡ್ರೈವರ ಏನು? R1 TC. 34.1. No steps need be taken as Shri F.S. Dabali submits that the only respondent is the VMTC and he represents them. 28 days. IA 1 of 2018 is filed seeking condonation delay of 28 days. Appeal admitted. TCR already agreed. Connected.
35, Recording success.
For appellant, my lord. 3 days delay.
3 days delay. Vijay Kumar, ಅದೇನೋ ಆಫೀಸ್ ಒಬ್ಜೆಕ್ಷನ್ ಆಗಿದೆ ಅಂತೆ ವಿಜಯ್ ಕುಮಾರ್.
Mute
ವಿಜಯ್ ಕುಮಾರ್
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಅದನ್ನ ಸ್ವಲ್ಪ ಅಟೆಂಡ್ ಮಾಡಿ ನಿಮ್ ವಕಾಲತ್ ಏನೋ ರಿಟರ್ನ್ ಆಗಿದೆ ಅಂತ.
That I'll verify and do the needful.
Kindly do that. IA 1 of 2018 CD of 3 days. ಅದು ಕಂಡು admit TCR.
36, Dear Ramakrishna.
ನೀವು ಯಾರಿಗೆ ನಾವು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕ್ರಿ. Notice on IA number 1, 2 and 3 of 2021. TCR.
37,
I appear for appellant, Mayor.
Palakshaya.
Respondent, my lords.
Palakshaya.
Please, my lords, I am for the respondent.
ಅದೇ ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ನಾ ಕಂಡೋನ್ ಮಾಡ್ತೇನೆ.
ಆಗ್ಬೋದು.
1 of 2018 233 days ಇದೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂತ ಇದೆ.
ಅದ್ ಮತ್ತೆ ನೋಡ್ಬೇಕಷ್ಟೇ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿನೈಲ್ ಆಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಅದೇ 233 ದಿವಸ.
38,
ಅಡ್ಮಿಟ್ ಆಯ್ತಾ?
Vijay Kumar.
ಆಯ್ತಾಯ್ತು. 376 days of IA 2 of 2018.
My lord, I am for the appellant, my lord.
ಅದಿಲ್ಲ.
Delay may be condoned.
ಓಕೆ ಸರ್, ಡನ್.
And one
ಗೋಪಾಲ
more.
ಕೃಷ್ಣ ಅವ್ರದ್ದೊಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ 251 ದಿನ ಇದೆ. ಕಂಡೋನ್
ಅದು
ಮಾಡ್ತೇನೆ.
condone ಮಾಡಿ without interest. Without interest.
Mr. Vijay Kumar, you take notice for R1 in his cross
I'll
objection.
take it. I'll take it.
Vijay Kumar is directed to take notice for R1 Here Gopalakrishna is directed to furnish one set of papers to Shri D. Vijay Kumar forthwith. ಇನ್ನೊಬ್ರು ಇರೋದಾ
My lord, one more matrix.
issue notice
One
to
more connected matrix.
IA1 of 2019, 251 days, heard condoned denial of interest for 251 days.
One more matter is there, my lord.
ಹೇಳಿ.
My lord, this matter is connected with one more matter, 5792/18. 5792/18. May kindly be connected of
All
2018.
along with number 3. Next,
39,
modification of the interim order dated 5/12/2000 filed by R1 and R2. What is the modification? You appear for whom, sir? Insurance, owner. No insurance. You want some release, is it? ಎಟ್ಲೆ ಮಾತಾಡ್ತೀರಿ ಮಾತಾಡಿ ಶ್ರೀ ವಿಶ್ವನಾಥ್ ಕೆ learned counsel for the appellant submits that the appeal is by the owner of the vehicle and there was no insurance coverage and appellant is willing to settle the matter by discussing the same with the claimant. Yes, time ಬೇಕು. He prays for 4 weeks time for the said purpose. List after 4 weeks. ನೀವು ಪ್ರೆಷರ್ ಹಾಕಿ ಮತ್ತೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿದ ಮೇಲೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಏನ್ ಇಂಜುರಿನಾ ಡೆತ್? ಮತ್ತಿನ್ನ ಅಂತ ಸೆಟ್ಲ್ಮೆಂಟ್ ಸತ್ತೋಗಿದ್ದಾನೆ. ಯಾವ ಏಜು? ಏನ್ ಏಜು? liability, that sword of Damocles will be hanging on you. Please pay up. ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಇಂಟ್ರೆಸ್ಟ್ ನಲ್ಲಿ ಕಡಿಮೆ ಮಾಡಿದ್ರೆ ಮಾಡಿ, ಬೇಕಂದ್ರೆ 2 weeks ಸಾಕು, ನಾ ಹಾಕ್ತೇನೆ 2 weeks ನಂತರ ಮಾಡ್ಕೊಳ್ಳಿ. ಲೀಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
okay, Renuka Richard,
My lord, the amount has been, the interim order has been complied with on 9/3/2020, my lord.
Learned counsel ಶ್ರೀಮತಿ ರೇಣುಕಾ HR submits that. ಎಷ್ಟು ಫುಲ್ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ 50% ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು.
Submits that appellant has deposited 50% of the award amount before the tribunal. ಯಾವಾಗ?
On 9/3/2020, my lord.
9/3/2020. ಇದು MACT ಮುಂದೆ ಮಾಡಿದ್ದಲ್ಲ?
ಹೌದು.
ಓಕೆ, ಅಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡ್ಬೋದಾ ಮೇಡಮ್?
ಅದು ಸ್ವಲ್ಪ ಒಂದ್ಸತಿ ನೋಡ್ಬೇಕಾಗಿತ್ತು, ಯಾಕೆಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರಸ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಒಂದ್ಸತಿ ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಮಾಡ್ತೀನಿ. ಬಿಕಾಸ್ ಐ ಡೀಟೇಲ್ಸ್ my lord.
ಆಯ್ತು. admit TCR. Which is the connected matter?
ಅವ್ರಿಗೆ ಫರ್ನಿಶ್ ಮಾಡಿ ಹೇಳಿದ್ದೀನಿ ಕಾರ್ಪೊರೇಷನ್.
ಆಯ್ತು. Next.
41, Siddheshwara Venkat,
My lord, I appear for appellant, my lord.
So, Krishna Swami, I will condone this small delay.
7 days delay, my lord.
Yes, my lord.
Denial of interest alla ಏನಿಲ್ಲ. Admit TCR.
42,
Dismiss, my lord. Your lordships kindly, my lord.
Fine. Admit TCR. Next matter.
42, Nagar Venkat,
1 of 2018 Benny, 35 days delay condone. Denial. Admit TCR. ಇದು ಕನೆಕ್ಟೆಡ್ ಬೆನ್ನಿ. ಇದು ಯಾರು? R2 ಅಂದ್ರೆ ಇದು ಓನರ? You have already filed. Sri Ravi Penny, learned counsel for the appellant, submits that respondent number 1 is the owner. But ನೀವು R2 ಗೆ ಡಿಸ್ಪೆನ್ಸ್, R2 ಯಾರು? ಕ್ಲೇಮೆಂಟ್ ಅಲ್ವಾ? ಏನ್ರಿ? ಏನ್ ಮಾಡ್ತೀರಿ? ಏನ್ ಅದಕ್ಕೆ ಮೆಮೊ ಹಾಕಿದಾರ? ಅದೇ ಅದು ಈ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಬೆಣ್ಣೆ ಅವರು. ಹೌದ್ರಿ, ನೀವು ಮೆಮೊ ಬಹುಶಃ ಆರ್ಟು ಅಂತ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರಿ. ಮಿಸ್ಟೇಕ್. 500 ರೂಪಾಯಿ ಹಾಕಿ ಕೊಡಿ, ಇನ್ನೊಂದ್ಸಲ ಮಿಸ್ಟೇಕ್ ಆಗದೆ. ಇದು ನೀವು ಏನೋ ಹಾಕ್ಬೇಕಲ್ಲ, ಈಗ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆ. ನಾವು ಓರಲ್ ರಿಕ್ವೆಸ್ಟ್ ನಲ್ಲಿ ಹೇಗೆ ಮಾಡೋದು? ಶ್ರೀ ರವೀಶ್ ಬೆಣ್ಣಿ, ಯು ಆರ್ ಪ್ರೇಯಿಂಗ್ ಟೈಮ್ ಆರ್ ಶುಡ್ ಐ ಡಿಸ್ಮಿಸ್ ದಿ ಅಪೀಲ್? Hey, don't do that. I can't permit. There is an order on that. See, Ravish Benni prays for time. List after 2 weeks. Admit. 43 admit. 44 admit. 45 admit. 46 admit. 47 admit.
48
admit.
49
admit.
Okay, for
admit. 51 admit. FR ನೀವು ಸರಿ ಮಾಡ್ಬೇಕು ಆಮೇಲೆ.
51, my lord.
No FR.
51, my lord.
ಅಪ್ಡೇಟ್ ಮಾಡಿದ್ರು ಕೂಡ ಒಂದೇ ಒಂದು ಮಿಸ್ ಆಗೋಗಿತ್ತು.
In 51 is it?
ಅಪ್ಲಿಕೇಶನ್ ನಾನೇ
51, my lord. I pray for stay, my lord. The EP has been filed.
Wait. ಮೆಮೊ ಹಾಕ್ಬೇಕ್ರಿ, ಎಲ್ಲಾರು ಯಾರು ಎಲ್ಲ ಹೇಳ್ಬೇಕು. Learned Counsel Shri N.R. Ravikumara submits that respondent number 1 has passed away on 11/1/2016. ನೀವು ಅದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಹಾಕ್ತೀರಾ? ನಾನೇನು ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡೋದಿಲ್ಲ, ನೀವು ಅದು ಏನ್ ಬೇಕಾ ಮಾಡ್ಕೊಳ್ಳಿ. R3 R4 ಡಿಸ್ಪೆನ್ಸ್ಡ್ ವಿತ್ ಆಗಿದೆ. ಯಾವ್ದದು? FR. ನೀವು ಅದನ್ನ ಇಲ್ಲ ಅಂದ್ರೆ ಸರಿನೇ ಮಾಡೋದಿಲ್ಲ, ಅಟೆಂಡ್ ಆಗದೆ. ಎಸ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್.
Yes, my lord. I pray for stay, my lord. They have filed execution. I'll deposit 50%, my lord.
Really? What is the execution number?
That execution number, they are not mentioned, my lord. They just called me and said that TP has been filed, my lord.
Now
I'll
2000.
deposit.
This is 2000 matter. Unless you mention the EP number, I am not going to grant stay.
I deposit 50%, my lord.
You may deposit, but things should have some, office has not posted, because it is the duty of the office to post it. What to do?
Maybe call next week, my lord. I'll get the EP
I am
number.
not calling. You can move with the necessary application. I am not calling. Why should I inflate the list with this kind of thing?
When they called me, I told them to give me the EP number, but they are not.
Good. You made your effort. Insurance company is indolent. You don't suffer. Insurance company suffers. Indolent people should not be given any importance here. Yes.
52, Kalyanar.
Admit.
Here for second respondent.
Admit. 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 Admit appa. Admit. ಬೇರೆ ಕೇಸ್ ಇದೆಯಾ? Fine, fine. We will also answer. Wait for some time.
59,
Admit.
all brothers. 60,
ಇದು 283 days delay ಕಂಡೋನ್ ಆಗಿದೆಯಾ? The name of CM Punacha to be deleted.
IFA for respondent.
Ashishaila, this 283 days should
My lord, it may condone with no interest.
denial of interest for 283 days.
61. CH-28,
Admit.
62, Marigowda,
Admit.
3, Harish Bandari,
Admit. TCI.
64, Guru Prasad PR,
Admit.
5, Krishna DJ,
IFA for respondent.
Uday Kumar RS,
Admit.
67, Shivram SC,
Admit.
68, 58 Dayan,
Admit.
9, Nagaraj Hegde,
Admit.
70, Chandraj K,
Admit.
This is the claim dismissed, my lord. I am the respondent. The claim has been dismissed before below the.
We will consider that, not today, madam.
I see. I see.
71, K. Chandranath Ariga,
Here ಆಗಿದ್ದಲ್ಲ ಇದು.
It was heard.
You said you will appear, Mr. Krishna Swami.
Oh my lord, ಇವತ್ತು personal inconvenience ಆಯ್ತು. I really wanted to. I told my friends also.
Sorry. What happened? Did I pass some order on the policy?
No. Because the other side.
Mr. Krishna Swami, this policy is act policy or package policy or comprehensive policy?
Comprehensive policy. Comprehensive.
He admits that. He admits.
Yes. And the question is.
No, that whatever that is, what is that? B report file, B or C report? B, final report.
Yes.
So that the complete document was not here. So I asked him to be present,
Yes.
and yours also is not easily readable, legible. So what to do?
This is the complete record for the. We see 468, then we see 686, then we see 1936 and 198.
The problem is all Xerox due and the documents are incomplete. Now, so far as Vasant was driving one of them, isn't it?
Anil was driving.
That is Vasant. Who is Vasant?
Vasant is the son.
Some name.
Yes, Vasant.
So his son was the driver.
No. Anil Kumar was the driver. By the side of Anil Kumar, Vasant. Claimant son was sitting. Behind them, P. Ratan and Anil Kumar. Because there are two Anil Kumars. Behind the driver, Anil Kumar was.
So Anil was the driver. One Anil was driver. Another was passenger seat occupier.
In the hind seat.
So this Anil.
Yes.
driver, which is the claim petition?
The Anil Kumar, that is MVC.
So he is not, that is not 598 of 98.
But,
In this case,
that Anil Kumar's claim petition is not there.
so this is for the death of Vasant.
Yes,
The front left side occupied.
left side.
Occupied.
That the driver Anil Kumar, he later committed suicide. That has come in the.
So, Mr. Krishna Swami,
My lord.
so there is your liability. The driver of the car was negligent because the sketch map clearly shows he went to the far off side, that is right side, which was wrong side for him. Are you able to listen to me simultaneously, or there is some time lag?
My lord, I can understand. Yes, my lord is correct.
So your liability can't be questioned, isn't it?
As far as negligence of driver of car is concerned, there is no dispute. I agree with my lord.
You agree. The next in the sequence is, if the driver is negligent and your policy is a comprehensive one,
Risk of occupant is required to be covered by virtue of circular. My lord, point that is required to be considered is,
yes, sir.
whether there existed a policy of insurance at that point of time. 100 ಗಂಟೆಗೆ ಮುಗಿದೋಗಿತ್ತು.
Right.
12:10 ಅಂತ. Not in fact.
11:50, 12:10.
My lord, that is the only.
So only in the hospital document, that is that SCR, SCS or whatever.
Yes, hospital.
SCS hospital, 12:10 is mentioned.
Yes, basing on that one accident.
That was one Anil Kumar who had given.
Yes.
That is that passenger, Anil
That
Kumar,
is the passenger.
who suffered some fracture or something.
Yes.
But he is not the one here.
Yes.
But
that is the 3W4.
rest all show that it is 11:50. And you know, the one thing is the whole documents, whole of them, and that Sand fellow had said 11:50. When was the complaint lodged? Within 4 hours. Complaint was lodged within 4 hours of the accident by 3 a.m.
My lord, not 3 a.m. My lord. My lord would.
If I remember, it is 3 a.m. I don't now have those documents from this is what I recollect. 4 ಗಂಟೆಗೆ. Andre within 4 hours of the accident, the case was registered. And look at this situation. The fellow had suffered such a serious fracture. He will first go and tell the doctor this has taken place at 12:10, like the birth of a child. So horoscope has to be prepared. Krishna Swami?
My lord.
The complaint is within the most reasonable this thing. A police station was 1 kilometer away, or
my lord.
Look at the FIR, that is very close. Now you tell me. ಎಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಅಂತ ಇರ್ತದೆ ಅದರಲ್ಲಿ. ನಾನು ಏನೋ 1 ಕಿಲೋಮೀಟರ್ ನೋಡಿದಾಗ ಆಯ್ತು. 4 ಕಿಲೋಮೀಟರ್. So Krishna Swami, now you tell me. On the one side, complaint was lodged within a very reasonable time, because nobody immediately flies off to the police station doing something to rescue or shifting people. There were some injured. And do you think, does it accord with the reason that a person who is injured will give exact like the important event like birth of a child were important, even fraction of. Mr. Krishna Swami.
Yes, ma'am.
What does your reason tell you?
My lord, may I request my lord's kind attention to the liability aspect that is
Your
discussed.
request is entertained. Tell me what is liability now. Tell me what is liability.
My lord, the policy of insurance had lapsed.
Sir,
Well-
that again takes us back to this timing.
Timings only. Yes, yes. My lord,
ಮತ್ತೆ liability ಅಂದ್ರೆ ನಾನೀಗ ನಿಮಗೆ ಕೇಳಿದ ಕ್ವಶನ್ ಏನು 1210 ಅಂತ ಒಂದೇ ಒಂದು ಇರೋದು ಯಾವುದು SCS ಹಾಸ್ಪಿಟಲ್ ನಲ್ಲಿ ಆ ಪ್ಯಾಸೆಂಜರ್ ಕೊಟ್ಟಿದ್ದು.
ಹೌದು.
ಬೇರೆ ಯಾವುದು ಇಲ್ಲ ಇದೆಯಾ?
ಬೇರೆ ಯಾವುದು ಇಲ್ಲ ಇದೆ ಅನ್ನೋದಕ್ಕೆ 1210 ಪ್ರಾಬಬಿಲಿಟಿಗೋಸ್ಕರ ಮೈ ಲಾರ್ಡ್ ವಿ ರೆಡ್ ದಿ ಬಾರ್ ಕಂಪ್ಲೀಟ್ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ದೇ ಸ್ಟಾರ್ಟೆಡ್ ಡ್ರಿಂಕಿಂಗ್ ಅನ್ನೋದನ್ನ
ಇದು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ?
ಮೈ ಲಾರ್ಡ್,
ನಮ್ಮ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇರುವ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ? ಅಂಡ್ ಅಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ ಎಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಅಂತ ಎಲ್ಲಿ ಯಾರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ? ಆಕ್ಸಿಡೆಂಟ್ ಸೈಟಿಗೂ ಆ ಕುಡಿದ ಜಾಗಕ್ಕೂ ಎಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಅಂತ?
ಮೈ ಲಾರ್ಡ್, this could not, they could not have reached that place within that time ಅನ್ನೋದಕ್ಕೆ
ನೀವು ಈಗ ಸರ್ಚ್ ಮಾಡ್ತೀರಿ, ಆಮೇಲೆ ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದವರು ಅಲ್ಲಿಂದ ಇದ್ದೀರಿ, ಈಗ ಹುಡುಕ್ತಾ ಇದ್ದೀರಿ. ಮೊನ್ನೆನೂ ನಾನು ಅದೇ ಕೇಳ್ತಾ ಇದ್ದೆ.
ಅಲ್ಲ ಇವತ್ತು ಆ ಲೋಕ ಅದಾಲತ್ ಮೀಟಿಂಗ್ಗೋಸ್ಕರ ಹೊರಟಿದ್ದೆ, ಮಧ್ಯಾಹ್ನದ ಬಾ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಬರ್ತಿದ್ದೆ. Could it be taken up at 2:30 minutes? I will come there. Whatever happens, I take it.
Okay, then 2:30. ಅದೊಂದು ಯಾವ್ದೋ KH ಚಂದ್ರಶೇಖರ್ ಯಾರೋ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿ ಈಕೆನಾ? ಈಗ ಒಂದು ನಿಮಿಷ ನೋಡಿ ಬಿಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಫಟಾಫಟ್. ಮೇನ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆಸ್ ದಿಸ್ KA-10494. ಅದು ಯಾವ MEC ಇದು ಅಂತ ನೋಡಿದ್ರೆ ಆಯ್ತು. ನೋಡ್ತಾ ಗೊತ್ತಾಗ್ತದೆ. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತೀರಿ? ಮಿಸ್ಟರ್ ಮಹೇಶ್, now we are on MFA 10494. Kindly give me the MEC number in this.
Yes, my lord. This is the MEC number, my lord, 510 of 2018, my lord. 2008.
ಒಂದು ನಿಮಿಷ.
That is connected with MFA 6135 of 2010.
135.
Yes.
72.9.
MFA 10,494 of 2010 is connected, my lord, and arising out of the same accident in MFA.
ಅಂದ್ರೆ ಅದು 510 of 2008.
510 of 2008. Karkala, MSCT Karkala.
ಓಕೆ, ಇನ್ಯಾವ್ದಾದ್ರೂ ಇದೆಯಾ ಇದು ಕನೆಕ್ಟೆಡ್?
ಅದಷ್ಟೇ. That has to be separated.
ಆಯ್ತು. ನೀವು ಇನ್ಯಾವ್ದಲ್ಲಾದ್ರೂ ಈ 72 ಸೀರೀಸ್ ನಲ್ಲಿ ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ?
72 ಸೀರೀಸ್ ಅಲ್ಲಿ ಇದೆ, ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is
ನಾನು ಅದನ್ನು ಗಮನಿಸ್ತಾ ಇದ್ದೇನೆ. ಅದಕ್ಕೆ ಈ ಸೀರೀಸ್ ನಲ್ಲಿ ನೀವು ಬೇರೆ ಅಪೇರ್ ಆಗುವಂತದ್ದು ಇದೆಯಾ?
ಇಲ್ಲ, ಇವೆರಡೇ ಕೇಸ್ ಅಷ್ಟೇ ಇರೋದು.
ಅಲ್ಲ ಸರ್, ಇದು 72.5 ನಲ್ಲೂ ನೀವು ಇದ್ದೀರಲ್ಲ?
ಇದೀನಿ, ಅದು ಬೇರೆ ಕಂಪನಿ ಇರೋದು.
ಸರಿ, ನೀವು ನನಗೆ MEC ನಂಬರ್ ಕೊಡ್ಲಿಕ್ಕೋಸ್ಕರ ಕೇಳ್ತಾ ಇದ್ದೇನೆ. MEC,
I'll give the MEC number, my lord. In MFA 6101 of 2010,
MEC,
my lord, 7114 of 2005.
7114 of 2005. ಇದು ಬೆಂಗಳೂರದ?
This is Davangere, my lord.
ದಾವಣಗೆರೆ. 6102 ನಲ್ಲಿ MEC ಎಷ್ಟು?
6102 ನಲ್ಲಿ 7245 of 2005.
7245 of 2005. ಇದು ದಾವಣಗೆರೆನಾ?
That is all Davangere, my lord. Royal Sundaram, my lord, is the appellant.
6103 ಅಲ್ಲಿ MVC
6917 of 2005. 6917 of 2005. Sorry, my lord, 89, my lord, 89.
6989
8917 of 2005.
Eight seven.
ಅಲ್ಲ 6103 ಅಲ್ಲಿ 8917 8917 ಮೇಡಮ್.
8917. ಇನ್ನು ನೆಕ್ಸ್ಟ್ 6104 ನಲ್ಲಿ ನೀವು ಯಾವ್ದಾದ್ರು MEC
8918 of 2005.
18 of 2005.
That is Ryle Sundaram, my lord.
ಆಮೇಲೆ 6192
6192, my lord, is MEC 5957 of 2008 of Oriental Insurance.
ಈಗ ಇಷ್ಟು ನೀವು ರಿಪೇರ್ ಆಗ್ತೀರಲ್ಲ. ಮುಂದೆ ಒಂದು 6527 ನಲ್ಲಿ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೀರಿ. ಅದು
6526 272829 by APSRTC, my lord.
ಇದು ದಾವಣಗೆರೆಯಿಂದ ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, ಇದು Bangalore, my lord. Series of cases in Bangalore. That is filed by Mr. Vijay Kumar.
ಸರಿ.
My connected appeals, my lord, is different.
ಆಯ್ತು. ಈಗ 6526 MEC ಎಷ್ಟು? 6526 of 2010 MFA 7217. ನಿಮ್ ಲಿಸ್ಟ್ ನೀವು ನೋಡ್ತಾ ಇರೋದು?
My lord, MSc 714 of 2005 MSCT Bangalore by APSRTC, my lord.
Okay. ಆಮೇಲೆ 6527
that is all connected, my lord, this thing. Up to MFA 6529 of 2010.
ಅಂದ್ರೆ ಇದೆಲ್ಲ erasing from a common order.
Common order, my lord, common order.
Up to which number you said?
6529 madam. 6529 of 2010.
6529. ಅಂದ್ರೆ 1 2 3 4 ಅಲ್ವಾ? 4
APSRTC 4, my lords, 4 matters.
ಮೇಡಮ್, ನೀವು ಅದನ್ನೊಂದು ಮಾಡಿ ಆಮೇಲೆ ನಾವು ಆರ್ಡರ್ ಮಾಡೋಣ. ನೋಡಿ ಮಾಡಿರ್ತೀರಾ?
ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಂಡು MVC ನಂಬರ್ ಹಾಕೊಂಡು ಬ್ಯಾಚ್ ಕನೆಕ್ಟೆಡ್ ಕಾಮನ್ ಆರ್ಡರ್ ಇರೋದು.
ನಾನು ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ ಆನ್ ದಿಸ್ ಡಿಲಿಂಕಿಂಗ್ ಅಂಡ್ ಆಲ್ ದಟ್ at 2:30.
One more small submission, my lords.
I will give time.
ಅಲ್ಲಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ MFA 6102 ಫೈಲ್ ಬೈ ರಾಯಲ್ ಸುಂದರಂ, ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ಬೇಕು. It is above 15 lakhs.
That I am not considering. I will you make submission at 2:30. I will request the registrar judicial to look into that. 2:30, kindly be there.
Much okay.
At that time, my court officer will have looked into which are the connected and all that. If you have anything to say on that, I will hear you. Otherwise, today only for delinking and linking appropriate cases, as the case may be. Then I will give some short time because 2010 matters.
ಯಾಕಂದ್ರೆ ಇದ್ರ ಜೊತೆ ಒಂದು MFA 5633 of 2010 get below ಅಂತ ಇದೆ, ಅದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಅದೇ ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ. ಅದು ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ತಗೊಳ್ಬೇಕು, ಆಮೇಲೆ ನೋಡೋಣ. ಸರಿ ಸರ್, ಅದನ್ನ ಅವರಿಗೆ ಹೇಳಿ. 2:30 ನಾನು ತಗೊಳ್ತೇನೆ. ಇವಾಗಲೇ ಅವರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡಿ. ನಡುವೆ ಲಂಚ್ ಬ್ರೇಕ್.
I may be excused till 2:30, my lord. I got some other work. I'll come back at 2:30, my lord.
No, which are your matters?
There are connected matters, my lord. They are shown.
ಅಂದ್ರೆ ಇದು 72 ಬೇರೆನಾ?
ಅಲ್ಲ, 74, my lord. Serial number 74, 75, 79 onwards, my lord.
I will just see if you are needed to be heard. I will adjourn. Otherwise,
I'll come at 2:30. I'll come at 2:30, my lord. I'll make thing. I ask for accommodation, my lord, till 2:30. I got some personal work, my lord. I'll go and come back, my lord.
ಆಯ್ತು ನೋಡ್ತೇನೆ ನಾನು ಯಾವ್ದಾನ ಅನ್ಸೋದು ಸೀರಿಯಸ್ ಲೀಗಲ್ ಇಶ್ಯೂ ಇದ್ರೆ ಐ ವಿಲ್ ಅಜರ್ನ್ ಅಂದ್ರೆ ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್ at 2:30 if there is any
serial number 74 is concerned, my lord. If it is, my lord, kindly have it instead of 2:30, my lord, kindly have some other day, my lord. 74.
There are 4 matters, my lord. There are 4 matters.
ಆಯ್ತು ನಾಳೆ ಏನು ಬ್ರೇಕ್ ಇದೆಯಾ ಏನು ಹೇಳಿಲ್ಲ ಆಯ್ತು ನಾನು ಐ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್ ಆನ್ ಮಂಡೇ
Please, much obliged.
ಈ 4 ಇದು ಕನೆಕ್ಟೆಡ್ ತಾನೆ
ಹೌದು ಕನೆಕ್ಟೆಡ್
ಅದ್ರಲ್ಲಿ ಏನು ಇದಿಲ್ಲ ಅಲ್ಲ
ಇಲ್ಲ
ಪ್ರಾಪರ್ಲಿ ಲಿಂಕ್ಡ್ ಅಲ್ಲ
by Rai Sundaram case.
Yes.
And they are arising from common judgment
Yes,
and award.
common judgment, my lord.
Learned counsel Shri O. Mahesh submits that he has some inconvenience. Full hence list on Monday. Nadi Monday baratte.
Much obliged.
72, my lord.
Wait. Ade at 2:30.
73, Sripadvi Shastri. 73, Sripadvi Shastri, H.M. Keshav Prashant.
Mr. Prashant, have you received a copy?
Yes, madam. I received it. I received the copy, my lord. I have gone through the
This is
judgment.
that Bailey case. Mr. Prashant, I seem to have told you, please appear.
My lord, no, my lord, I have gone through the records. I am admitting my liability, my lord. I am admitting liability to the extent of 1 lakh as far as PA coverage is concerned. In view of my lord Ram Kiladi case, I have no dispute.
Yes.
So that is the only thing.
6-7, 6-1-7 by 11.
What is the other point? This Bailey I heard, no fresh argument.
78.
ಅದ್ರಲ್ಲಿ ಮತ್ತೆ ಇಂಟ್ರೆಸ್ಟ್ ಬರುದಿಲ್ಲ ನೋಡಿ
ಬರೋದಿಲ್ಲ
ಅಲ್ಲ ನೀವು ಅಸಂಪ್ಷನ್ ನಲ್ಲಿ ಇರಬಾರ್ದು ಐ ಮಸ್ಟ್ ಇಫ್ ಯು ಹ್ಯಾವ್ ಎನಿಥಿಂಗ್ ಟು ಸೇ ಆನ್ ದಟ್ ಪ್ಲೀಸ್ ಸೇ ಅಂದ್ರೆ ಅವರು ದಿ ಲಯಬಿಲಿಟಿ ಫೇಸನ್ಡ್ ಆನ್ ಇಟ್ ಇಸ್ ದಿ ಲಯಬಿಲಿಟಿ ಫೇಸನ್ಡ್ ಆನ್ ಇನ್ಶೂರೆನ್ಸ್ ಆರ್ ಓನರ್ ರಾಮ್ ಕಿಲಾಡಿ
ಅಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್ ಇಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5.8 ಮೆಲಾಡ್ ಅದರಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್
ಕೊಡಿ ರಾಮ್ ಕಿಲಾಡಿ
Special contract, they are going to pay 1 lakh.
There was one interesting judgment. Which para, Mr. Bhatt?
Paragraph number 6 ಅಲ್ಲಿ ರಾಮ್ ಕಿಲಾಡಿ ಕೇಸಲ್ಲಿ there's a last paragraph, my lord. In that, my lord,
For the reasons the present appeal is partly allowed to the opposite held that original claimant shall be entitled to a sum only with the interest. They have given interest. Then who has to pay this?
The special contract, originally 50 rupees to 1 lakh contract.
This accident is of which year?
like this is for 2008, my lord.
Then 5 lakhs alwa. See 5.8.
Alala 5 lakhs, my lord. That is only with respect to, my lord, section 163A. But this is, my lord, with regard to PA coverage only. They are not entitled for, my lord, 163A petition. Supreme Court has held, my lord, they are not entitled under section 163A, but they are entitled only to the extent of PA coverage. That is what, my lord, the Supreme Court has held in paragraph number 5.8, my lord. If your lordship permit, my lord, read that.
1 lakh. Okay. No, thank you. So this is on that short question.
Yes.
That is bailer.
Section 148 ಆಗುತ್ತೆ ಅದನ್ನ ನಾವು ನೆಗೆಟಿವ್ ಮಾಡಬಹುದು because the legal masses ಅಷ್ಟೇ it is all mine.
Where is Ningamma? Which para in Ningamma? Notes ಎಲ್ಲಿದೆ madam? ಅಂದ್ರೆ ಯಾವ ಪಾರ ಓದ್ತಾ ಇದ್ದೀರಿ? ಇದರಲ್ಲಿ ತೋರಿಸಿ. No problem. Just see and let me know. This is an act policy with the PA coverage of rupees 1 lakh. Now, just kindly mark on the para with pencil. Just you kindly mark. I will just. Please. ಇದರಲ್ಲಿ ನೀವೀಗ ಕೊಟ್ಟಲ್ಲ ಯಾವ್ದದು ರಾಮ್ ಖಿಲಾಡಿನಲ್ಲೂ ಇಫ್ ಯು ಹ್ಯಾವ್ ದಟ್ ಡಿಸಿಷನ್ 5.4 ನಲ್ಲಿ ಡೀಲ್ ಮಾಡಿದ್ದಾರೆ.
Yes, madam. That was also considered, my lord, in Ram Khiladi case.
ರಾಮ್ ಕಿಲಾಡಿ ಇದೆ.
ಇದೆ. No, he claim lies, but he doesn't say further that it is against the insurance company. I am not going. This requires, I can't, you see, a decision is an authority, like, it is said in the famous judgment, Quinn versus Latham. That decision is an authority for what actually is laid down therein, not not an authority for actually what inference you can draw from it. No, you will further argue on that. Yes. Let's not, decision should be read as an authority for what has been laid therein, not for what follows from that. It is not a statute.
ಕಾಫಿ ಮಾಡಿ ಇಲ್ಲ ಇನ್ನ ಯಾಕೋ ಲೇಟ್ ಆಯ್ತು. ಹೌದೌದು ಅದೊಂದು
This appeal is at the instance of the claimants calling in question the legality and correctness of the judgment and award dated 4/8/2010.
May I make one submission? Matter division mention reach ಆಗ್ತದೆ. Permits, my lord, I will attend that case.
Okay. In MPC number 2422 of 2008, passed by the Motor Accident Claims Tribunal, Court of Small Causes, Bangalore, it has dismissed your petition, isn't it? Dismissing the claim petition. Next paragraph. The claimants approached the tribunal with an application under section 163A of the Motor Vehicles Act 1988, alleging that one Manjunatha, hereinafter referred to as deceased anta adannu single inverted bracket goes, was a son of claimant numbers 1 and 2 and brother of claimant numbers 3 and 4. And on 21/2/2008 at about 7:45 a.m., he was riding a motorcycle bearing registration number KA51L7130 belonging to belonging to the first respondent hearing from Hoskote to Malu, and he met with an accident and he died due to the injuries suffered in the accident. Company respondent appeal. Second respondent herein is the insurer of the motorcycle in question. Next para. Before the learned tribunal, the owner of the motorcycle remained ex parte. Insurance company contested the proceeding by filing a written statement. Next part. During trial, claimant number 1 examined himself as PW1 and exhibit P1 to P10 were marked. Insurance company examined one of its officials as RW1. Next part. After hearing the learned counsel on both sides and perusing the records, the learned tribunal dismissed the claim petition. Next para. Learned counsel for the appellant claimant, Shri A.K. Bhatt, continuously contended that while it is true that the deceased Manjunath was not the Manjunath had borrowed the motorcycle in question from its owner, who is respondent number 1 herein, and he met with a fatal accident while riding the same. He also submits that the claim petition is undoubtedly under section 163A of the Motor Vehicles Act 1988, within bracket Act for short, the Act for short. Bracket close. He also submits that he is aware of the decision of the Honorable Supreme Court in Lingama and another versus United India Insurance Company Limited. Within bracket AIR 2009 SC 3056, which clearly lays down that a borrower of the insured vehicle steps into the shoes of the owner, and therefore he, being a tortfeasor, cannot make a claim against the insurance company. In the insurance company ಅಲ್ಲಿ ಯಾರ ಮೇಲೂ ಲಯಬಲ್ ಅಲ್ಲ ಅಂತ ಹೇಳುತ್ತಲ್ಲ ನಿಂಗಮ್ಮದಲ್ಲಿ. He being a tortfeasor, he cannot maintain a petition under section 163A of the Act. Full stop. He further submits that he is also aware that in a subsequent decision of the Honorable Supreme Court, reported in AR 2020 SC 527, within bracket Ram Khiladi and another versus United Insurance Company, United India Insurance Company Limited, and another bracket close. Honorable Supreme Court has said, even in cases of claim petition being under 163A of the Act, and claimants are the dependents of the tortfeasor, if the Act policy, if the policy of insurance covers the personal accident coverage, to an extent of the liability taken upon itself by the insurance company, compensation is required to be awarded to the said extent only with the appropriate interest thereon. However, his substantial contention is that when the deceased borrows the motor vehicle from the insured owner, there is a relationship of bailer and bailee, and it is substantially in the nature of a bailment, and therefore the provisions and therefore the rights and liabilities should be determined under section 148 of the Indian Contract Act 1816 as actually. Full stop. He further submits that ನೀವು ಹೇಳೋದು ಮೆಕ್ಯಾನಿಕಲ್ ಡಿಫೆಕ್ಟ್ ನಿಂದ ಇದಾಗಿದೆ ಅಂತಲ್ಲ. No, ಅದು you should say that there is defect, otherwise this duty will not arise. Are you saying that there was some latent defect? 150. You say that there is, otherwise this argument will not lie. Latent defect ಅಂತ ಹೇಳೋದ ನೀವು? What is patent and what is latent? Okay. Fine. He further submits that there was, what is the patent defect? It is not supported by pleadings. ಅದಕ್ಕೆ ನಾ ಹೇಳೋದು ನಿಮ್ದು it cuts at your own feet. You can't take it anywhere. Why are you maintaining such an argument? With this, when I answer that by saying there is no plea, then there is no, it will not stand there. You should take up this plea in a better case, mister, but don't unnecessarily make me spend my time. Okay, fine. He further submits that relationship. Bailor, B-A-I-L-O-R, and Bailee, B-A-I-L-E-E. The transaction is one of bailment, and therefore the rights and liabilities of the parties should be determined with reference to section 150 of the Contract Act, Indian Contract Act of 1869. Very full stop. He submits that the said aspect has not been looked into by the learned tribunal, and therefore ನೀವು ಹೇಳೋದನ್ನು ರಿಮಾಂಡ್ ಮಾಡ್ಬೇಕಂತ. This is not considered. I can't stop at that. There should be some prayer related to this. I don't know. Logically, what do you want? Instead of that, instead of doing this, I simply filed 153. He therefore submits that he submits that the judgment and award impugned herein is illegal for non-consideration of the said aspect, and it is liable to be set aside. Full stop. Next paragraph. Learned counsel CH-28 Prashant, appearing for the respondent insurance company, per contra submits that in view of the policy including the liability of personal accident coverage comma, all that the claimants are entitled to be entitled to is a sum of rupees 1 lakh with the appropriate interest thereon. He submits that the rest of the claim made under section 163A of the Act is totally is not maintainable in view of the decision of the Honorable Supreme Court in Ningama's case, within brackets Supra, a full stop. Next paragraph. I have given my anxious consideration to the submissions made on both sides, and I have carefully perused the records. The claim petition is filed under section 163A of the Act, full stop. Claimants are the dependent legal representatives within the meaning of section 2G nagal. Legal representatives ಅಂತ ಇದೆಯಲ್ಲ ಸೆಕ್ಷನ್ ನಲ್ಲಿ MU ಆಕ್ಟ್ ನಲ್ಲಿ ಡಿಪೆಂಡೆನ್ಸ್ ಅಂತ ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅವರು 163 ಅಲ್ಲ 2G ನ ಏನೋ ಇದೆ ನೋಡಿ legal representatives. Claimants are the legal representatives of one Manjunath who had died in the accident. Within the meaning of section 2, yavado ide nodi. It was discussed in detail in Birender's case. Act tegiri. Full stop. The pleadings clearly disclose that deceased Manjunath had borrowed the motorcycle in question from the owner, who is respondent number 1 herein. And while he was riding the motorcycle on account of his own negligence, the accident resulted and he succumbed to the injuries. Since the death in the accident occurred due to the negligence of the deceased himself, he is a tortfeasor himself. As held by the Honorable Supreme Court in Ningama's case, Supra, since he is a tortfeasor and a borrower from the owner, he stands in the shoes of the owner himself, and therefore the claim petition under section 163A of the Act is not maintainable. Reference under para 17, 18, and 19. Close. However, admittedly, the policy had a coverage for the personal accident liability to the extent of rupees 1 lakh. In view of the decision of the Honorable Supreme Court in Ram Khiladi Supra, the claimants are entitled to award of rupees 1 lakh with the interest thereon at 6% per annum from the date of the petition till the date of payment. Next part. Insofar as
My lord, the honorable court is muted, my lord. The honorable court is muted. We are not able to hear. Court audio is muted, my lord. Court audio is muted.
Now, can you hear me?
Yes. Now.
Okay. He further submitted that there was a patent defect in the motor vehicle, namely the motorcycle in question. And therefore, respondent number 1, the owner, was under an obligation to disclose the same to deceased Manjunath, and he having not done the same, the deceased borrowed the motorcycle, and while he was using the same, he met with an accident, and therefore the owner is liable to pay the compensation, and insurance company is bound in law to indemnify the same. The said submission is wholly misconceived in view of the fact that said contention is not supported by even an iota of pleading in the claim petition. There is no averment in the claim petition that there was patent defect in the motorcycle in question, and the owner respondent number 1 was aware of the same, and that he failed to divulge the same to deceased Manjunath. In that view of the matter, the said contention for want of pleading, which was not even advanced before the learned MACT, which was the tribunal of the first instance, cannot be entertained in this appeal. Accordingly, the same is rejected. And the following, the appeal is allowed in part in modification of the judgment and award dated in MEC so and so, passed by so and so, insurance company is directed, and the respondent number 2 is directed to pay a sum of ₹1 lakh to the claimant within 4 weeks, within 6 weeks from today, with the interest thereon at 6% per annum from the date of the petition, the date of payment. Transfer the records to the learned court below, learned MACT court.
Court officer. Court officer. Mute ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. What is this? Oh my God.
ಏನು ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಕೋರ್ಟೇ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಹೈಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ ಮೇಡಮ್.
ಅದು ಕಾಣಿಸ್ತಾ ಇದೆ ಬಟ್ ಈ ಕೋರ್ಟ್ ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನಾಯ್ತು ನಮ್ದು ಮ್ಯಾಟ್ರ್ ಅಂತ ಕೇಳಲ್ಲ ಅಂದ್ರೆ ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರೆ.
ಹೌದು ಮೋಸ್ಟ್ಲಿ ಸಾಹೇಬ್ರು ಎದ್ದೋದ್ರೇನೋ ಅನ್ಸುತ್ತೆ.
ಇದ್ದೋಗಿರೋ ಒಂದ್ 5 minutes ಬರ್ಬೋದೇನೋ ವಾಪಸ್. It's not there. What is that? Court officer? Court officer?
Seventy-four absent. Bill number 75, Kamala DK.
I am appearing for the appellant, my lord.
Mr. Mahesh
I have filed
said,
synopsis.
you have filed.
I have filed synopsis along with the rulings, my lord.
Has he filed, Mr. Mahesh? 230. ಅವ್ರೇನೋ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಸರಿ ಸರ್.
ನೀವು ಯಾರಿಗೆ? 74. ಆಯ್ತು.
My lord, court audio is muted, my lord.
Can you hear me?
Yes.
76. Mr. Venkatesh.
Marikarjan facility. K. Chandrasekhar.
ಇಲ್ಲಿ ಬೇರೆ ಸೌಂಡ್ ಏನೋ ಕೇಳಿಸ್ತಾ ಇದೆ.
Yes, Mr.
My lord, only simple issue before this court is whether insured being a claimant is eligible for compensation for death of his wife, who was a leader of a motorcycle, driver by Mr. Harisha. This is the only question before the court, my lord. Last time I have mentioned some of the one judgment which my lords told me to get the latest judgments which I have searched for. I can only get two more, my lord. One to Satarana Mukhi versus OIC.
One ನಿಮಿಷ sir.
ಸರಿ
ಬರ್ಕೊಳ್ಳಿ. ಹೇಳಿ 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 ವೆಂಕಟೇಶ್. ಅಲ್ಲ
2008 ACJ 1441.
Party's name ಹೇಳಿ sir.
OAC versus Rajni Devi and others.
ಅಲ್ವಾ ಸರ್?
ಇನ್ನ ಒಂದಿದೆ ಮೇಡಮ್, ಪ್ಯಾರಾ 8 ಇದರಲ್ಲಿ.
ಇನ್ನೊಂದು ಹೇಳಿ ಸರ್.
ಹೇಳ್ತೀನಿ. 2020 ACJ 627.
627. Party's name is
Ram Kiladi versus United India.
Ram Kiladi.
ಫಸ್ಟ್ ಇಂದ ಯಾವ್ದಂತೆ?
Rajni Devi 2008 ACJ 1441.
Next, madam, 2009 ACJ 998. NIA versus Sadanandamukhi.
Who?
NIA versus 2009 ACJ 998. NIA versus Sadanandamukhi and others. Para 4.
9 ACJ 998.
Yes, my lord. And Dhanraj last time ಹೇಳಿದ್ದೆ ಕೋರ್ಟ್ಗೆ 2005 ACJ 1. Dhanraj versus NIA.
ತಕೊಳ್ಳಿ ಮೇಡಮ್. ಅಲ್ಲ ನೀವಲ್ಲ, ಅಡಿಷನ್ ತೆಗಿದೆ ಆಯ್ತಾ?
ರಾಮ್ ಕಿಲಾಡಿ ಇದೆ.
ತರ್ಸ್ಬೇಕಾ? ಅದು ಎಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ವಾ ಸರ್?
ಎಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮೇಲೆ.
ಸುಪ್ರೀಂ AIR ಸಿಗ್ತದೆ.
ACJ 1441.
ಪಾರ್ಟಿ ಹೆಸರು
Oriental versus Rajni Devi.
ಸ್ಪೆಲ್ಲಿಂಗ್ ಕೇಳಿ
ಸರ್. ರಜನಿ ದೇವಿ ಸ್ಪೆಲ್ಲಿಂಗ್ ಹೇಳಿ.
ಬಂದೆ.
ಬರ್ಕೊಳ್ಳಿ.
RAJNIDEVI ಮೇಡಮ್.
ರಾಮ್ ಕಿಲಾಡಿ ಇದೆ. 2009 ACJ 998. ಸರ್ 2009 ಪಾರ್ಟಿ ಹೆಸರು ಒಂಚೂರು ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ. ನ್ಯಾಷನಲ್ ಇನ್ಶೂರೆನ್ಸ್ ವರ್ಸಸ್
Sadanandamukhi and others, madam.
Okay.
ಅದು AIR 2009 1788 1788. The problem with Mr. Lakshmi Narasimha, you should also come here, give the slip, because we have to spend lot of time. Please be here.
ಸರಿ ಯಾವತ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಕುಡ್ ಗಿವ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ನಿಮ್ ಕೇಸ್ ಇದ್ದಾಗ ಇಲ್ಲಿ ಬಂದ್ಬಿಡಿ.
ಸರಿ ಸ್ವಾಮಿ, ಇನ್ಮೇಲೆ
ತುಂಬಾ ಕೇಸ್ ಇರತ್ತೆ ನಿಮ್ದು ಯಾವಾಗ್ಲೂ.
ಇಲ್ಲ ಇನ್ಮೇಲೆ ಬರ್ತೀನಿ ಸ್ವಾಮಿ.
ಅಲ್ಲಿಂದ ನೀವು ಹೇಳೋದು ಇಲ್ಲಿ ಎಷ್ಟು ಟೈಮ್ ನೋಡಿ.
ಟ್ರೂ ಮೈ ಲಾರ್ಡ್, ಟ್ರೂ. ಬಟ್ ಸರಿ ಸ್ವಾಮಿ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇಂದ ಬರ್ತೀನಿ ಸ್ವಾಮಿ.
ಯಾರೋ ಒಂದೊಂದು ಕೇಸ್ ಇರೋರಾದ್ರೆ ಪರವಾಗಿಲ್ಲ, ತರಿಸ್ತೀರಲ್ಲ. No, in this Sadanand Mukhi case, Mr. Narasimhaya, Lakshmi Narasimhaya,
ಹೇಳಿ ಸ್ವಾಮಿ.
the rider was the son of the insured owner.
ಹೌದು ಸ್ವಾಮಿ.
He himself died.
ಹೌದು.
This is not directly on the point.
Though it's not directly on the point, my lord, the Honorable Supreme Court, while giving a detail, kindly come to para 4, my lord.
1 minute. This petition is under
This
what
is under
section?
166, my lord.
166.
The petition before this court is under 166. Death.
What is the name of the deceased?
Srimati Shweta Rao, my lord. Wife of insured Ashok Rao.
He was riding the motorcycle.
No, he was not riding, my lord. As per the documents available with the court, it is Harisha riding the motorcycle.
Now, who is claimant number 2?
Claimant number 2 is the mother of the deceased, Bhagya Bai. In the cross-examination, PW1 admitted that she is living separately. She has her own family and all that thing, my lord. I will place on before the court the cross-examination of PW1.
But does the who are the class 1 heirs for the woman?
Husband. and children.
Just see, the Hindu Succession Act.
It is admitted in the cross-examination, my lord. By even the learned judge also notified that the only claimant is the husband, and 50% have been deducted as a loss of dependency, taking a monthly income as a tailor, my lord. That's also noted at page number 7, para number 12, my lord. Issue number 2, para 10.
He has no children.
No, my lord.
ಸಿಗ್ಲಿಲ್ಲ ಪುಸ್ತಕ. ಓದಿ ಇದು ಯಾವುದು ಸದಾನಂದ ಮುಖಿಯಲ್ಲಿ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಓದಿ. ಆ 230 ಬರ್ತೀರಾ?
ಹ್ಞೂ ಸರಿ ಸ್ವಾಮಿ, ಆಯ್ತು. ಆಮೇಲೆ
I'll take it up at
ಸರಿ 230 ಆದ್ರೂ ಸರಿ, ತಮ್ಮ ಕೋರ್ಟ್ ಹೆಂಗೆ ಹೇಳಿದ್ರೆ
230.
ಸರಿ ಸ್ವಾಮಿ.
Addition ತರ್ಸಿದೆಯಾ?
That's I appear for the respondent number 3. ಇದರಲ್ಲಿ ನಾವು ಫೈಲ್ ವಾಪಸ್ ಕಳಿಸ್ಬಿಟ್ಟಿದೀವಿ ಕಂಪನಿಗೆ. ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು. ಈ ಕೋರ್ಟ್ ಕೇಸ್ ಸ್ಟೇಟಸ್ ಚೆಕ್ ಮಾಡಿದ್ರೆ 28/1/2016 ಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತಿದೆ.
ಕೇಸ್ ಸ್ಟೇಟಸ್ ಆಗಿ ತೋರಿಸ್ತಾ ಇದೆ ಅಂತ. ಕುಡಿ. Learned counsel for the appellant is absent, no representation. Seeking enhancement, Mr. Anup, oh, you don't have.
ಅಲ್ಲ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಏನು ಇಲ್ಲ, ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಇನ್ ಹಿಸ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದ ಪೆಟಿಷನರ್ ಸೇಸ್ ಯಾವ ಗಾಡಿ ಗುದ್ದಿತು ಬಸ್ಗೆ, ನೀವು ಹೋಗ್ತಾ ಇದ್ದಿದ್ ಬಸ್ಗೆ ಅಂದ್ರೆ ಯಾವ ಗಾಡಿನೋ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಕ್ಲೇಮ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಲಾರಿ ಅಗೇನ್ಸ್ಟ್.
Counsel for the appellant is absent, no representation. The claim petition was dismissed by the learned MACT under the impugned judgment and award. The appeal dismissed for non-prosecution. Okay. Yeah, Kumar Swami. Dismissed for non-prosecution.
Much obliged.
ಏನಾರ ಅಲ್ಲಿ ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ನಾವೇನ್ ಮಾಡೋದು? ಲಿಸ್ಟ್ ಅಂತ ಇದೆ ಆ ಡೇಟಿಗೆ, ಅದಂದ್ರೆ ಅದು ಪ್ರಿವೇಲ್ ಆಗತ್ತೆ. ಇದೆ ಅಂತಂದ್ರೆ ಇದು
78 MR Kumaraswamy.
I am for the first respondent. There is no liability on the BMTC.
Vijay Kumar, ಇದೇನು ರವೀಶ್ ಬೆಣ್ಣಿ ಅವರು ಇನ್ನೊಂದು
Ravish Benny Insurance Company, they have also filed appeal. I think he is before the court.
This BMTC or KSRTC?
I am for BMTC.
Your bus is covered by insurance, is it?
Yes, my lord.
One ನಿಮಿಷ. So he is the primary liable. You have to indemnify. If the petition is allowed, that is the position. Okay. Your appeal has 1960 days delay. Why should I entertain?
It is after lapse of more than 6 years.
Now, what was the judgment and award?
Judgment is passed against the insurance company. Direct to pay the compensation, and they have satisfied the award also.
They have satisfied.
They have satisfied the award. Yes.
What is you are questioning liability or quantum?
Now they cannot question the liability.
Agree. 1,43,000 was award was 1,43,000. Could you application could application could IA 1 of 2017.
There is no valid and sufficient reason to condone the delay.
IA number 1 of 2017 is filed seeking condonation of delay of 1990 days in filing MFA Crop 83/2017. The appeal is by the insurance company. The affidavit in support of the application is sworn to by one A.K. Sinha, the occupation of the deponent is left blank in the ಕೆಳಗಡೆ ಬರೆದಿದೆ. Occupation blank ಮಾಡಿ ಮತ್ತೆ ಕೆಳಗಡೆ I am working as left blank ಬೇಡ. He is stated to be working as deputy manager in the insurance company. The affidavit is as bland and as vague as can be conceived. Stop. Relevant portion of the affidavit reads as follows. Para affidavit in para 2, 3, 4, and 5. Stop. The fact stated in the affidavit do not make out any ground and do not offer valid and sufficient reasons as to how the cross-objector was prevented from preferring the cross-objection within the time limited by law. In view of the same, IA number 1 of 2017 is dismissed. Consequently, MFA Crop 83/2007 stands dismissed. 217 is the MFA. Learned counsel for the appellant is absent, no representation. Appeal dismissed for non-prosecution. Yes, yes. You can't do if your officer does this kind of thing. Benny, I can't hear you. If your officer, you haul him up, recover it from him. Huh? These people should learn. 79.
Hello, Santosh.
This next week. Whom I submit that he has some personal inconvenience and he plays time this next week.
80, DS Sanjeev.
This case I prefer the respondent, my lord. I filed citations along with authorities and also some brief facts on the last occasion.
You appear for whom?
I prefer the respondent.
You are Sri Sanjeev. Where is your brief? You straight away go to the judgment. Without factual background, how can that be? Yeah. That's why I asked you to submit a brief note. Because last time I found, it is difficult to keep you under a certain framework. Went on and on. 87, 1,74,201 was awarded. Now the same, the claimant is seeking enhancement, and you are questioning what is your legal contention. Only substantial question of law. Are you questioning employer-employee relationship? No. Employer-employee relationship. Admitted. This accident taking place in the course of and arising out of the employment. Admitted. This is KSRTC or private? KSRTC bus. KSRTC. KSRTC bus. Bearing number? AA 1999. He was conductor. Last order 11/4/2011. So all these things. What is your earning? Fine. Wait. Don't be in such a breakneck speed like some of your drivers are. don't go in such a breakneck speed like some of your drivers do on the road. You have little consideration for us. It's a little slow. So this thing is you have accommodated him within your organization where there is no loss of pay. Is there any loss of prospect of his getting promotion? Where is that order marked? No, sir. Did you not get it marked?
Exhibit
Your
R.
order giving him that employment. He was a conductor. He had an employment-related accident. He suffered some disability. These are not in question. Whether really there was any loss in the income, that is the question. That is the sole question here. You say that there is no loss of income. She says there is loss of income. And in support of your case that there is no loss of income, you say you have accommodated him as a helper, which is a desk job. Where is that order? First thing is you did not get it marked, I think. But you should at least have that here. We should know the terms of. Because last time I heard her saying, whether you are not there, whether you are there or not, I don't know. She said some allowances and promotional prospects and all that and all that. How long he has been in the employment? At the time of the accident, 99. When was he? Huh? ಮತ್ತೆ ಇದನ್ನು ಇಲ್ಲಿ ಬಂದು ಹುಡುಕುತ್ತೀರಂತೆ. Yes, madam, shortly. Now tell me in short. What was the term of this offer of alternative position?
That is helper B.
ಹೌದಮ್ಮ, ಅದರಲ್ಲಿ ಏನ್ ಟರ್ಮ್ಸ್ ಹೇಳಿದ್ದಾರೆ?
Terms ಏನಿಲ್ಲ ಅದರಲ್ಲಿ.
How do you demonstrate that there is a loss in your earning?
Because exhibit R1, your lordship may kindly see, salary certificate produced by them.
Madam, R1 is the salary slip of a conductor or a helper?
Conductor, helper.
He's a new position as helper.
Yes, ma'am.
Where is that R1?
March 99, exhibit R1. So his salary was 5,653 as a conductor. That is 90 March. But accident was 26/3. Again, your lordship may kindly see, May 99, his salary was rupees 4,532.
You want me to see R1 and R2, is it?
R1 is the salary certificates produced by them in lump sum. Modulinda March 2099 inda up to 2002, 2007 they produced.
They are a bunch of pay slips.
Yes. Helper B for class 4 employee category. Conductor means, my lord, he might have get some overtime and promotion.
Overtime depends on, it is not a definite this thing.
March 99.
The compensation for working overtime, that can't be considered as, that is contingent on some.
March 99, your lordship may kindly see, that he was working as a conductor.
1 minute, madam. So exhibit
R1.
R1
R2. 130 pages.
R3.
R1 is the order.
R1 is first is March 99.
Yes.
That was as conductor.
5,653.
ಮೂಲ ವೇತನ 1142.58. ಇದೆಲ್ಲಿದೆ ಹೆಲ್ಪರ್ದು ಮೂಲ ವೇತನ?
ಹೆಲ್ಪರ್ದು
ಹೆಲ್ಪರ್ ಒಂದು ಯಾವ್ದೋ ಇದೆ ನೋಡಿ, 3rd July 2004. ಮೂಲ ವೇತನ ಅವಾಗ ಇನ್ಕ್ರೀಸ್ ಆಗಿದೆಯೋ ಗೊತ್ತಾಗ್ತಾ ಇದೆ.
ಅಷ್ಟೊತ್ತಿಗೆ ಬಿಕಾಸ್ 99 ಆಬ್ಸ್ಟೆಂಟ್ ಅಲ್ವಾ ಸ್ವಾಮಿ, ಅದು
ಪೇ ರಿವಿಷನ್ ಆಯ್ತಾ ಏನು?
ಪ್ರಮೋಷನ್ಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಸ್ವಲ್ಪ ಆ ಕೇಡರ್ಗೆ. ಕ್ಲಾಸ್ 4 ಎಂಪ್ಲಾಯೀಸ್ ಇರ್ತಾರಲ್ಲ ಆ ಕೇಡರ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಜೂನ್ 99 ಅವನಿಗೆ ಆಗಸ್ಟ್ 99 ಅವನನ್ನು ಹೆಲ್ಪರ್ ಅಂತ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೆ ಯಾವಾಗ ಮೇಡಮ್?
ಅವಾಗ 7/12/2002
ಅಲ್ಲಿ ತನಕ ಕಂಡಕ್ಟ್ ಅಲ್ಲಿ ತನಕ ಕಂಡಕ್ಟ್
ಸಂಬಳ ಕೊಟ್ಟಿದ್ದಾರೆ. when he was hospitalized they have given salary and other facilities.
ನಿಮ್ಮ ಹೆಲ್ಪರ್ ಆರ್ಡರ್ ಕೊಡಿ. ಹೆಲ್ಪರ್ ಅಂತ ನಿಮಗೆ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ
7/12/2002 my lord, exhibit R1.
ಅದನ್ನ ನೀವು have you produced it?
No, they have produced exhibit R1.
Okay. Even that you don't know alla Mr. Sanjeev. You are Sanjeev? Junior P. Venkatagiriyappa andre ivrena?
Conductor avre claimant.
Junior assistant cum data entry operator Kolar. Examined by orthopedic doctors this hospital. Adu R3
disability certificate by medical board. SNR hospital.
R3 ಮತ್ತೆ R2 ಎಲ್ಲಿದೆ?
R1 my lord, R1 ಅವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು.
ಏನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿದೆ ಅಂತ. ಅದೇ ನೀವು ಹಾಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಬಂದ್ರೆ ಹೆಲ್ಪ್ ಆಗತ್ತೆ. ಅಲ್ಲಿಂದ
RW1 ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ ಎಕ್ಸಿಬಿಟ್ RW1 that is Aslam Beg. Junior assistant was examined as RW1. Helper B due to the injuries, it is true that on 7/12/2002 the petitioner has
who is Munirame Gowda?
Munirame Gowda
is the RW1 I think.
No. Aslam Beg is the RW1. 17/2/2003.
Madam is Aslam Beg ಯಾವುದು ಇದು? ಇದರಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ ಯಾರು? ವೆಂಕಟಗಿರಿಯಪ್ಪ ನೋಡ್ರಿ, ಇದು ಯಾವ್ದೋ ವೆಂಕಟಪತಿ ಅಂತ ಇದೆ.
ಸುಕ್ಕಪ್ಪ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ, ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ 25/1/2011 after remand. First 2003 it was decided by taking his disability as 80%. 80%. They have taken 80%. Commissioner has
RW1 now. ವೆಂಕಟಗಿರಿಯಪ್ಪನೂ ಇದ್ದಾರೆ.
ಯಾರ್ರಿ RW1? ಮಿಸ್ಟರ್ ಸಂಜೀವ್
ಸುಕ್ಕಪ್ಪ ಇಲ್ಲಿ ಅಫಿಡವಿಟ್ ಎವಿಡೆನ್ಸ್ ಇರೋದು ಸುಕ್ಕಪ್ಪ ಅಂತ. ಅಗೇನ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಅಸ್ಲಾಮ ಬೇಗ್ RW1 ಅಂತ ಇದೆ. He was also classified.
I will post this after 4 weeks because I can't make out that document is here.
No, my lord.
Evidence. And from the assistance, this remote assistance, I can't locate those documents. RW1. I don't know whether records are wrong or that's why a physical presence helps. I can't spend time like this.
ಮುನಿರಾಮೇಗೌಡ RW1 ಅವರು ಮುನಿರಾಮೇಗೌಡ SRTC RW1.
What can I do? Sorry, madam. Here, what I find as RWN is some Muniswamegowda.
Not Muniswamegowda, my Aslama Beg obru.
Ramegowda.
Ramegowda. Exhibit R1 is available. Sipars ಮಾಡಿರೋದು. May I read, my lord? Exhibit R1.
ಅವರು
ಅದೇ ಜಾಬ್ ಬೇರೆ ಕೊಟ್ಟಿರೋದು.
ವೆಂಕಟಪತಿ ಅಂತಾರೆ, ವೆಂಕಟಗಿರಿ.
May I read, my lord?
I am not able to. I need assistance here. That reading, I am not able to connect the document from my record.
Yes, 7/12/2002. I exhibit R1.
ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ಡಿಸಬಿಲಿಟಿ ಎಲ್ಲ ಕಡೆ ವೆಂಕಟಗಿರಿ.
Exhibit R1 ಇದೆ ನೋಡಿ ಮೇಡಮ್.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ, ನಾನು ತಗೊಳ್ತೇನೆ. Not immediate, next week. But madam, you may have to come here to point out from the court record to compare your document with that. Because they don't tally. When should you? When do you want?
Court is not audible. Yes, I will come. Your lordship may kindly fix a date. Court is not
I
audible.
am trying my best to be audible.
Yes, sir.
My system shows
Yes, my lord.
I am on.
Yes. Now,
But,
now
what
audible.
is the difficulty? I do not know.
Now audible, my lord. Now is audible.
Now audible. When do you want? You tell me.
Any date your lordships may kindly say.
Next week. Next ಗುರುವಾರ ಯಾಕಂದ್ರೆ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿ ಗುರುವಾರ ಎಂತದ್ದು ಒಂದಷ್ಟು ಲಿಸ್ಟ್ ಹಾಕಿಲ್ವಾ ಇಲ್ಲ ಇಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ.
Yes, ma'am.
ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅವರು
H.N. Keshav Prasad.
I appear for the appellant in this case.
ಕೊಡಿ ಮೇಡಮ್ ಅವರೇ ಅಲ್ಲ ಏನ್ ವಿಶ್ವನಾಥ್ ಅವರು. What is it you are questioning liability?
This is with regard to liability aspect. But my contention is that the claimant who is injured was traveling in the vehicle as a coolie. And
what was the vehicle?
It was a goods vehicle, not a lorry.
Lorry.
Oh. There are two claim petitions arising out of the same accident.
We are concerned with Mutturaj.
Yes, madam. That is with respect to MVC 1805 of 2010.
Truck. This fellow was. What is his pleading? He says he was a passenger or
No, my lord. My submission is that he was traveling as a coolie, but as per rule 100 of the motor vehicle rules, 7 person can travel, including the driver of the vehicle in question. This is heavy goods vehicle, with a gross vehicle weight of 16,200 kgs.
Any interstate thing is involved?
This thing is, my liability is restricted to the Workmen's Compensation Act, because I have not collected additional premium to cover any of the coolies as per section 140.
This is statutory liability.
Yes, my lord. Statutory liability is there, only to the extent of the Workmen's Compensation Act. So just I wanted to take your lordship's kind attention to the judgment rendered by the Honorable Apex Court in National Insurance Company versus Prem Bhai Patel case.
Prem Bhai.
Yes, sir. 2005 ACJ 1323, my lord.
There is no subsequent decision?
No, my lord. This is a full bench judgment. It is not at all, my lord, overruled. Still, my lord, this judgment holds good.
Prem Bhai.
Yes, National Insurance Company Limited versus Prem Bhai, PREM BAI. Patel.
Continuous or
Prem Bhai Patel, space is there.
PREM
space Patel, PATEL.
Prem Patel.
Prem Bhai Patel.
BAI na BHAIN.
PREM BAI.
ಅಂದ್ರೆ ಒಂದೇ ವರ್ಡ್
ಒಂದೇ ವರ್ಡ್ PREM BAI. Next space quote Patel, PATEL, and others. 2005 ACJ 1323, my lord.
Okay. Prem Bhai. AIR 2005, madam. AIR 2005 SC 2337. This Prembai case was filed under 166, is it?
Yes, madam. ಇದರಲ್ಲಿ 147 with regard to the limits of liability and requirement of policy ಬಗ್ಗೆ discuss ಮಾಡಿಬಿಟ್ಟು judgment was rendered.
Which para you want?
Before due respect to your lordship, before going to the judgment, just I wanted to submit the facts of this case. And also, with regard to the Karnataka Motor Vehicle Rules 100, also, may require for consideration of your lordship.
Yes.
The examine evidence of PW1, my lord.
No, facts first. You state.
Facts are there. They are traveling.
So accident is on what date?
3/6/2009, my lord.
3/6/2009. This is a case of injury.
Case of injury.
Yes.
They were traveling as a coolie in the insured vehicle. The driver drove the same in a rash and negligent manner, and the vehicle was toppled. And due to that, my lord, the claimant was traveling on the top of the goods, which was loaded, my lord, the stones. He was traveling on the top of that, my lord, the stone kuchas, and fell down and, my lord, suffered injuries. This is, my lord, the fact. Well, there is no dispute with regard to that. The claimant, my lord, has also admitted in his evidence that he was traveling on the top of the goods. He was not sitting on the cabin. But for this aspect, my lord, I wanted to take your lordship the Karnataka Motor Vehicle Rules 100.
The rules for the madam.
There is no dispute, my lord, with regard to, my lord, if any goods vehicle, not more than 7 heavy goods vehicle, 7 persons can travel. My lord, I wanted to take your lordship's kind attention, my lord, to Rule 100, subsection 4, my lord.
Sub-rule 4. No person shall be carried.
No person shall be carried in any goods vehicle, my lord, unless an area of not less than 0.40 square meters of the floor of the vehicle is kept open for each person, and be in such manner that such person, when carried on goods, is otherwise in danger or falling from the vehicle. But this aspect, my lord, wanted to take your lordships. But he was admittedly, my lord, he was sitting on the top of the goods, on the, my lord, the stone kuchas. That was admitted fact, my lord, in the evidence of PW1. So, my lord, this aspect was not at all considered by the MSCT, my lord, was present in liability. But no person can be carried on the top of the goods unless.
What is your cross-examination on this aspect?
Yes, please. Blood,
it is only when you question it.
Yes, my lord. I have put the cross-examination question is there, my lord. Just, my lord, I will read the particular, my lord, the cross-examination of PW. Cross-examination of PW1, my lord. I was working under one Shivu Mahadeva Gowda. I know him since I was working under him.
One minute, sir.
Yes, ma'am.
PW1,
my lord.
PW1.
Mutturaj, who is the claimant, my lord, in this case.
Mutturaj. Yes, please. Where are you reading?
Cross-examination, lord.
Cross-examination. I was working under
one Shivu Mahadeva Gowda. I know him since I was working under him. 4 persons were working under him. He got one lorry. The said lorry used for carrying stones and cartoon materials. And driver Ravi took me to get a work. The lorry loaded with the stones was moving from Jigini to Malavalli. I was sitting on the stones, was moving from sitting on the stones loaded on the vehicle.
Correct.
Yes, madam.
ಇದು ಫ್ಲೋರ್ ಆದ್ರೆ above ಇದನ್ನ ಇಲ್ವಾ ನಿಮ್ದು ಎಲ್ಲಿ ಕ್ವಶನಿಂಗ್?
My point is, my lord, with regard to this rule 100, my lord, no person, that such a person, when carried on goods, is otherwise in a dangerous falling from the vehicle.
Where is this question put where is this elicited that he was sitting in such precarious manner against the rules, and there was every chance of his falling off.
ಅಲ್ಲ ಅವ್ರ ಕೇಸೇ ಫುಲ್ ಲೋಡ್ ಆಗಿತ್ತು ವೆಹಿಕಲ್
ಫುಲ್ ಅಂದ್ರೆ ಎಷ್ಟು ಹೈಟ್ ತನಕ ರೀ? ಫುಲ್ ಅಂತಂದ್ರೆ ಏನು?
ಅದ್ರ ಬಗ್ಗೆ ಏನು
ಫುಲ್ ಅಂದ್ರೆ ವಿದಿನ್ ದಿ ಮೀನಿಂಗ್ ಆಫ್ ದಿ ರೂಲ್ ಓನ್ಲಿ.
ಅದ್ರ ಬಗ್ಗೆ ಎಷ್ಟು ಹೈಟ್ ಇತ್ತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನಿಲ್ಲ,
ಏನು ಇಲ್ಲ. ಕವರೇಜ್ ಇತ್ತಾ ಇಲ್ವಾ? ಏನು ಇಲ್ಲ.
ಅದ್ರ ಬಗ್ಗೆ ನಾವೇನು
ಮತ್ತೆ ಹೌ ಡಸ್ ಇಟ್ ಹೆಲ್ಪ್ ರೀಡಿಂಗ್ ಆಫ್ 100?
Fine, I agree with them. But with regard to liability aspect, with regard to liability aspect, my contention is, my liability is restricted to WC Act, since no additional premium was paid by the owner of the vehicle to cover any of the coolies.
Now the rules require that you should cover statutory coverage. That is, whatever is liable, you should pay.
Yes,
that doesn't depend on you are making you are collecting premium.
For that,
that is compulsorily liable, compulsory statutory liability.
Oh, statutory liability there. I agree with that. But only to the extent of WC Act, if additional premium is not paid. That is what
where it is said under section.
Supreme Court has called out the same aspect in Bhai Patel's case.
Yes, sorry. You are referring to 2005, Allah?
Yes, sir. Paragraph number 11, my lord. With regard to the requirement of policies and limits of viability was discussed.
Before that was directed, the apprentice has preferred this appeal by special leave against the judgment.
I read, my lord.
Respond to Shiman Patel was owner of such national insurance. Sundar Singh, aged about 55 years. Employed by him.
Yes, para 11 and 13 is relevant. Para 11 it was discussed about the provision of section 147. The contention raised turn on the interpretation of subsection 1 of section 147 and 149 of the Act, and the same are being reproduced below. 147, requirement of policies and limits of liability. In order to comply with the requirements of this chapter, a policy of insurance must be a policy which is issued by a person who is an authorized insurer, and B, insures the person or classes of persons specified in the policy to the extent specified in subsection 2 against any liability which may be incurred by him in respect of the death of or bodily injury to any person or damage to any property of a third party caused by or arising out of the use of vehicle in a public place. against the death of or bodily injury to any passenger of a public service vehicle caused by or arising out of the use of vehicle in a public place, provided that a policy shall not be required to cover liability in respect of the death arising out of and in the course of his employment of the employee of a person insured by the policy, or in respect of bodily injury sustained by such an employee arising out of and in the course of his employment, other than a liability and arising under the Workmen's Compensation Act 1953 in respect of the death of or bodily injury to such employee engaged in driving the vehicle. If it is a public service vehicle, engaged as a conductor of the vehicle or in examining the tickets on the vehicle. If it's a goods carriage being carried in the vehicle, or to cover any contractual liability. But the next, with regard to this, the policy shall not be required to cover liability in respect of death arising out of and in the course of employment of the employee of a person insured by the policy, or in respect of bodily injury sustained by such an employee arising out of and in the course of his employment, other than a liability under the Workmen's Compensation Act. Liability is there, but only to the extent of the Workmen's Compensation. Next, the paragraph number 13. Paragraph 13. If you last wanted, I will continue with paragraph of 12 also. Paragraph 12, it is the heading of chapter 11 of the Act. The heading of chapter 11 of the Act is Insurance of Motor Vehicles Against Third-Party Risks, and it contains section 145 to 164. Section 146(1) of the Act provides that no person shall use, except as a passenger, or cause or allow any other person to use a motor vehicle in a public place, unless there is enforced in relation to the use of the vehicle by that person or that other person, as the case may be. A policy of insurance complying with requirements of Chapter 11, Class B of subsection 1 of Section 147 provides that a policy of insurance must be a policy which insures the person or classes of persons specified in the policy, to the extent specified in subsection 2, against liability which may be incurred by him in respect of the death of or bodily injury to any person or passenger, or damage to any property of a third party caused by or arising out of the use of vehicle in a public place. Subclass 1 and 2 of Class B are comprehensive in the sense that they cover both any person or passenger. An employee of owner of the vehicle, like a driver or a conductor, may also come within the purview of the words any person occurring in subclass 1. However, the provision 1 to Class B of subsection 1 of Section 147 says that a policy shall not be required to cover liability in respect of the death arising out of and in the course of his employment of the employee of a person insured by the policy, or in respect of the bodily injury sustained by such an employee arising out of and in the course of his employment, other than a liability arising under the Workmen's Compensation Act. If the employee is such as described in subclass A or B or C, the effect of this provision is that if an insurance policy covers the liability under the Workmen's Compensation Act in respect of the death of or bodily injury to any such employee as is described in subclasses A or B or C or provision 1 to Section 147(1)(b), it will be valid policy and would comply with the requirements of the Chapter 11 of the Act. Section 149 of the Act imposes a duty upon the insurer to satisfy judgments and awards against persons insured in respect of third-party risks. The expression such liability as is required to be covered by a policy under Class B of subsection 1 of Section 147 being a liability covered by the terms of the policy occurring in subsection 1 of Section 149 is important. It clearly shows that any such liability which is mandatorily required to be covered by a policy under Class B of Section 147 has to be satisfied by the insurance company. The effect of this provision is that an insurance policy which covers only the liability arising under the Workmen's Compensation Act in respect of the death of or bodily injury to any such employee as described in subclass A or B or C of provision 1 to Section 147(1)(b) of the Act is perfectly valid and permissible under the Act. Therefore, where any such policy has been taken by the owner of the vehicle, the liability of the insurance company will be contained to that arising under the Workmen's Compensation Act. Next paragraph. The insurance policy being in the nature of contract, it is permissible for an insurer to take such a policy where under the entire liability in respect of the death of or bodily injury to any such employee as is described in Class B, A or Clause A or B or C of the provision 1 to section 147 1B may be fastened upon the insurance company, and the insurance company may become liable to satisfy the entire award. However, for this purpose, the owner must take a policy of that particular kind for which may be required to pay an additional premium, and the policy must clearly shows that the liability of the insurance company in case of death of or bodily injury to the aforesaid kind of employee is not restricted to that provided under the Workmen's Compensation Act, and is either more or unlimited depending upon the quantum of premium paid and the terms of the policy. Now, this is what I wanted to take your lordship's kindness.
Yes.
If he has paid additional premium, then definitely my liability is to the unlimited extent. But if there's no additional premium is paid, my liability is only to the extent of the Workmen's Compensation Act as held by the full bench judgment of Honorable Apex Court. The case on we have not collected any additional premium towards coolies. I have produced the copy of the policy before this Honorable Court along with my application also on 9/12/2015 itself.
You have produced the policy.
Yes, I have produced the copy of the policy along with the application, and that
fine. They are not disputing it.
That application was also allowed.
So now, what is the final result? What did the Supreme Court do?
The Supreme Court, paragraph number 18.
The record shows that no stay order was passed in favor of the appellant. In case the appellant has judgment of the High Court in relates to quantum of compensation.
Yes, ma'am. Quantum is required to be reconsidered by your lordship.
Ability of the appellant insurance company to satisfy would be restricted to that arising under the Workmen's Act. Okay. So this is the final outcome. You are liable only to that extent.
So, with regard to when it comes to WC Act liability, with regard to
we are not quantifying. That has to be done in the execution proceeding.
Execution amount determine because tribunal has considered the claim petition under section 166 and entire liability is fastened against the insurance company. In view of this, my liability is only to the extent of WC Act. So in view of WC Act, the quantum is required to be determined. So that
by
I will
whom?
satisfy the order. That order may be.
No, who has to determine this?
Either by your lordship or it may be remanded back to the MACT for fresh consideration in view of the fact. Again, going back to the MACT, my humble request, that can be quantified here itself. It's only a short point for consideration.
No, it requires medical evidence.
Yes, everything
medical
is there.
Evidence, pointed evidence.
Everything is available on the record.
Loss. How can I do that?
Everything is available on record.
What is available here?
Even doctor evidence is there. Tribunal is also discussed with regard to the nature of injuries and disability suffered.
What is which is the wound certificate? This Mutturaj
is marked as exhibit P10. P10.
Mutturaj into P10.
Really, your lordship may kindly see the paragraph number. Paragraph number 11 of the judgment. Elladunu called out Madidar. The nature of injuries, doctor evidence, disability suffered. Everything is considered elaborated by the MACT. Paragraph 11, page number 6 of the judgment.
Yes, sir.
In this connection, apart from including oral evidence, the petition has got produced and marked the wound certificate and exhibit P4, which reveals the following injuries: tenderness over the right hip with abnormal mobility, swelling and tenderness present over the right forearm. X-ray reveals.
Either exhibit P4, even a wound.
P4, exhibit P10 is another case. X-ray reveals right hip dislocation with fracture of right ulna. It reveals that said injuries are grievous in nature. The discharge summary marked at exhibit P6 issued at Sanjay Gandhi Hospital, Bengaluru, reveals that the petitioner was admitted in the hospital on 4/6/2009 and discharged on 28/6/2009, and he was diagnosed for said injury. In addition,
pre-amendment time, so medical expense ಬರೋದಿಲ್ಲ ಇದರಲ್ಲಿ.
only my lord, with regard to my lord, disability and loss of earning capacity suffered. So my lord, 2009 only 4,000 rupees my lord, is required to be considered in view of the WC Act. Otherly 60% ತಗೋಬೇಕು. So that will come to my lord 2,400 rupees. 60% of 4,000. Then my lord, disability my lord, tribunal held my lord, tribunal at the disability 20% to the whole body.
Age ಎಷ್ಟು ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ?
But age is my lord is considered that my lord 21 years.
21. What is
21
the
years,
relevant
paragraph
factor?
number 14 my lord.
Relevant factor ಎಷ್ಟು?
Relevant factor my lord 222.71 my lord.
ಆಯ್ತು, ರೆಲೆವೆಂಟ್ ಫ್ಯಾಕ್ಟರ್ ಹೇಳಿ.
222.71 my lord.
222.71. 222.71.
Yes ma'am.
ಇವರು ಎಷ್ಟು ಅಂತ ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ?
20% to the whole body ಅಂತ ಹೇಳ್ತಾರೆ. Page number 8 my lord of the judgment, paragraph number 12 my lord continues. Page number last bottom ಅಲ್ಲಿ paragraph number 13 ಗಿಂತ ಮೊದಲು
upon considering the entire evidence, doctor, nature of injuries, evocation, I feel it appropriate to fix the permanent physical functional disability to the extent of 20%
to the whole body. This is what my lord. So my lord 2,400 only 20% to may be taken as my lord loss of earning capacity. With so my lord, applying the relevant factor. So this my lord would be my liability.
What do you say? Not necessary. It is a question of law. Now tell me, have you gone through this decision? Prem Bai clearly says, in such cases, the liability of the insurance company for indemnifying compensation is only to the limited extent that is payable under the Workmen Compensation Act, unless a special premium is taken by the owner to cover the whole liability. That is not the case. That is not the situation in this case. In this case, only that minimum premium was given, and therefore we have to go by Workmen Compensation Act. Give me, what is that? What is that? Yaudu? This arises from Workmen Compensation or MU Act? Then I will have to set aside and send it to Workmen Compensation. What do you want? Really there? Madam, which is the decision? The party has really. ಒಂದು ನಿಮಿಷ ಅಲ್ಲಿ ಇದೆಯಾ ಮೇಡಮ್ ಅದು ಸ್ಪೆಲ್ಲಿಂಗ್ ಐಡಿ ರಾಮಚಂದ್ರ ರಾಮಚಂದ್ರ ಸಿಂಗಲ್ ಹೆಸರಲ್ಲ ನಾವು ರಾಮಚಂದ್ರ ವರ್ಸಸ್ Ramchandra was the appellant. Madam, AIR 2013 SC 2561. 2013 ಅಲ್ಲ ಇದು AR 2013 SC 2561. Now, where is that Prembai dealt with that? That is a 3-judge bench, just out of curiosity. Paragraph 15. In support of counsel for insurance has invited the attention to the case of, in this matter, the claim petition had been filed by the respondent claiming compensation for the death of Sundar Singh, who was an employee of he died and the accident and claim petition was filed. The main question which arose for consideration was whether the was liable to pay the entire amount of compensation awarded or its liability was restricted to that which was prescribed under the workman's full stop. Interpretation is in consonance with the learned judges in this ruling held that this CM Jaya, wherein while interpreting relied upon which were also relied upon which were rendered in you read para 18 end. We'll continue at 2:30. You read para 18 full.
ಇಲ್ಲ.
What of sir? Court officer.
ಹೇಳಿ ಸರ್.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 75 KNH.
ನಿಮ್ದು ಏನು ಹಾರಂ ಮಾಡಿಲ್ಲ, ಅಡ್ಜನ್ ಆಗಿದೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ನೋಡಿ 79.
Court officer.
72 ಎಲ್ಲ
72 ಮಧ್ಯಾಹ್ನ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತಾರಂತೆ. 72
75 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
79 ಪಾಸ್ ಓವರ್ ಮೇಡಮ್.
75 ಪಾಸ್ ಓವರ್. 79 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸರ್.
Court officer. Court officer.
ಹೇಳಿ ಸರ್.
ಈ ಕೋರ್ಟ್ದು ವಿಡಿಯೋ ತುಂಬಾ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತಾ ಇದೆ ಹೊರಗಡೆ ನೋಡ್ಲಿಕ್ಕೆ.
ಮಲ್ಟಿ ಕಲರ್ ಬರ್ತಾ ಇದೆ.
ಮಲ್ಟಿ ಕಲರ್ ಅಲ್ಲ, ಇದು ಇದಾಗಿ ಕಟ್ಟಾಗಿ ಇದೇನೇನೋ ಆ ಕಡೆ ಸ್ವಲ್ಪ ನೋಡಿ ನೀವು.
ಹೇಳ್ತೀನಿ ಸರ್, ಹೇಳ್ತೀನಿ. ಕಂಪ್ಯೂಟರ್ ಸೆಕ್ಷನ್ ಹೇಳ್ತೇನೆ ಇವಾಗ, ಕರೆಸ್ತೇನೆ.
ಕರ್ಸಿ ಈಗ ಲಂಚ್ ಅವ್ರು ಕರ್ಸಿ, ಯಾಕೆಂದ್ರೆ ಅದು ಸಿಕ್ಕಾಪಟ್ಟೆ ಫ್ಲಾಶ್ ಆಗಿ ಒಂಥರ ನಮ್ಗೆ ನೋಡಕ್ಕೆ ಆಗ್ತದೆ.
ವಿಷ್ಣು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ ಕಳಿಸ್ತೀನಿ ಅಂದಿದ್ರೆ ಏನ್ ಮಾಡಿದಾರ ಗೊತ್ತಿಲ್ಲ.
ನೋಡಿ ಅದು ಸ್ವಲ್ಪ, ಇಲ್ಲಾಂದ್ರೆ ಆಫ್ ಮಾಡಿದ್ರು ಪರವಾಗಿಲ್ಲ ಅದು. ಯಾಕೆಂದ್ರೆ
ಅಲ್ಲ 72 ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಊಟಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟು
ಏನಂದ್ರು 72 ಏನಂದ್ರು ಅನ್ಮ್ಯೂಟ್ ಮಾಡು ಅನ್ಮ್ಯೂಟ್
ಏನಾಗ್ಬೇಕು ಹೊಸ್ಮೆಟ್
72 ಏನಂದ್ರು ಅಂತ
ಯಾವ್ದಾದಕ್ಕೂ ಕನೆಕ್ಟ್ ಮಾಡಿದರೆ ಇವಾಗೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ.
ಏನ್ ಮಾಡ್ತಾರಂತ ಫೈನಲ್ ಹಿಯರಿಂಗ್
ಬೈಫರ್ಕೇಟ್ ಮಾಡಿ ಇದ್ ಮಾಡ್ತಾರೆ.
ಅಷ್ಟೇ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅನ್ನೊಂದು.
ಟಾಟಾದಲ್ವಾ ಇದು ಅಪೀಲು? ನನ್ನ ಅಪೀಲ್ ಟಾಟಾದಲ್ವಾ? 70 ಇದು ಯಾವ್ಯಾವ್ದಕ್ಕೂ ಕನೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ.
ಅವ್ನ್ ಬೈಫರ್ಕೇಟ್ ಮಾಡಿ ಒಂದ್ ದಿವಸ ಹಾಕೊಳ್ಳೋದನ್ನ ಹಂಗಾರೆ.
ಹೇಳು ಸರಿಗ್ ನೀನು
ಹಾ
ಸರಿಗ್ ಹೇಳಪ್ಪ ಕೋರ್ಟ್ಗೆ ಅಂದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಮೇಡಮ್
ಆಯ್ತು, ಇನ್ನು ನೀವು ಹಾಕ್ಬೇಕು. ಲಿಟಲ್ ಲೇಟು ಇವೆಲ್ಲ this was dismissed before the MACT.
Five cases are filed. All cases are allowed. This is only on the basis of he has not given the evidence that other cases are allowed and paid the compensation the claimant.
ಆಯ್ತು, ಅದು ಬರ್ದು ಸಿಗ್ನೇಚರ್ ಏನಾಗಿಲ್ಲ. ಆಯ್ತು, ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಲೀಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. Yes, madam.
82. Keshav Prashant.
For the appellate in this case.
Para 18, ಅಲ್ಲ? ಅದಲ್ಲ ನಾ ಹೇಳಿದ್ದು. The hearing before that the unambiguously laid down, which is recorded hearing before, that the compensation payable to the employee nearly under the work and it can be expanded provided the contractual document, which is the policy of insurance, incorporates such clause regarding the premium to be paid, taking into account the nature of the policy. Now, what is the policy premium taken? Does it say the liability is only for workman compensation, Mr. Prashant?
We have not collected any additional premium.
No, whether your policy says so.
Yes, madam.
Liability is only.
I have produced, madam. Policy condition is also produced.
Where is that? Kudi. Or ಹಾಕಿದಾರಂತೆ 2013. What is that? This also says the same thing. he can always, owner can pay additional amount and get out of that minimum this thing. Where Mr. Prashant?
But, the first page, my lord, is the policy schedule.
ಅಲ್ಲ, ನಿಮ್ಮ WC ಗೆ ಮಾತ್ರ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಿ?
But page number 4 of the blood, the terms and conditions.
Page number
4 of the blood, policy terms and conditions.
Page number 4 ಅಂದ್ರೆ ತಡೀರಿ, ಅವರು ಹೇಳಿದ ನಂತರ ನೀವು ಹೇಳಿ. ಇಬ್ರು ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಹೇಳಿದ್ರೆ ಎಲ್ಲಿದೆ?
But section 2, my lord, liability to third parties. Subject to the limits of liability as
ಎಲ್ಲಿದೆಯಮ್ಮ? ಮಾರ್ಕ್ ಮಾಡಿದ್ರಾ? ಇದಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಟ ಕಾಪಿನ ನಿಮ್ದು ಬೇರೆ? Section 2. ಓದಿ ಪ್ರಶಾಂತ್.
But page number 4, my lord, provided always that the company shall not be liable in respect of the death, injury, damage caused arising beyond the limits of any carriage, way or through fare in connection with the bringing of the load to the insured vehicle for the loading thereon, or the taking away of the load from the insured vehicle after unloading therefrom, except so far as is necessary to meet the requirements of the Motor Vehicle Act. The company shall not be liable in respect of the death or bodily injury to any person in the employment of the insured arising out of and in the course of employment.
ಎಕ್ಸೆಪ್ಟ್ ಅಂದ್ರೆ ME ಆಕ್ಟ್ ಅಂದ್ರೆ ಮತ್ ನೀವು ಆ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ, AWC ಬರೋದಿಲ್ಲ. Then you have no case. See, this Ramchandra, have you read this Ramchandra?
No, but I tried to find out the judgment, but I was not able to get it done.
Thus, insofar as the view of the High Court is concerned, to the extent that compensation would be restricted to be paid only to the extent which is payable under the Workmen's Compensation Act, by making a sweeping generalization. You have AIR with you?
Yes, madam.
You have the app?
I have the app, I tried, but I was not able to connect it to that, madam.
ನಾನು ಪೇಜ್ ನಂಬರ್ ಹೇಳ್ತೇನೆ. AR 2013
3561, madam.
2561.
2561. May I request my to pass over this matter, so that I will go through the judgment and.
ಆಯ್ತು.
ಈ ತರ ಇಷ್ಟು ಲಿಂಕ್ಡ್ ಸೆಪರೇಟ್ಲಿ ಲಿಂಕ್ಡ್
with 72.9.
ಹೌದು. Still number 72.
My lord, 72/1, 72/3 connected.
72.9 is connected to 72.9. Allah?
72/1.1, 72.3 connected.
72.1 is connected.
72.3 ಅದರಿಂದಲೇ ಬರುತ್ತಾ? ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಅವಾರ್ಡ್.
ಹೌದು ಸೇಮ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್
72 main matter is connected with 72.9. 72.1 connected with 72.3. Correct ಆಗಿದೆ ಬರ್ದಿದ್ವಿ.
ಸರಿ 72.9 ರೆಸ್ಟ್ ಡಿಲಿಂಕ್ಡ್ ಅದರಿಂದ. ಆಮೇಲೆ 72.2 ಕ್ಲಬ್ಡ್ ವಿತ್ 72.4 ರೆಸ್ಟ್ ಎಲ್ಲ ಡಿಲಿಂಕ್. 72.1 linked with 72.3 ಆಯ್ತಾ. 72.5 ಗೆ 72.6, 72.7, 72.8, 72.12, 72.13, 72.14 and 72.15 ಅದಷ್ಟೇ ಆಯ್ತಾ. ಆಮೇಲೆ 72.16 with 72.21 ಅದೊಂದು. ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು 72.17 and 72.18 ಇದೆರಡು. ನೆಕ್ಸ್ಟ್ 72.22 with 72.23 and 30. ಇನ್ನು 72.24 with 72.25. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ 72.11 with 72.90. ಮತ್ತೆಲ್ಲ ಡಿಲಿಂಕ್. ಅಂದ್ರೆ ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಪೇಮೆಂಟ್ ಆಗಿದೆಯಮ್ಮ? ಆಗಿದೆ, ಆಗಿಲ್ಲ ಮತ್ತೆ ನಾ ಏನ್ ಬರುತ್ತೆ? ಪೇಮೆಂಟ್ ಆಗೋ ತನಕ ನಾ ಏನ್ ಮಾಡೋದು? ಐದರ್ ಯು ವಿಡ್ರಾ, ಇಫ್ ಯು ವಿಡ್ರಾ ಐ ಕ್ಯಾನ್, ಇಫ್ ಯು ವಾಂಟ್ ಟು ವಿಡ್ರಾ ಐ ಕ್ಯಾನ್ ಪರ್ಮಿಟ್. ಏನು ನನ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. 71 ಕೃಷ್ಣಸ್ವಾಮಿ ಯು ಹ್ಯಾವ್ ಕಮ್. Next week. At least next week. Mr. Krishna Swami, you want to read little further? You want to go through completely? ಈ ಪರೀಕ್ಷೆಗೆ ತಯಾರಾಗುವಾಗ ಅಲ್ಲ ಕಂಪ್ಲೀಟ್ ಯಾವಾಗ್ಲೂ ರೆಡಿ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಗೋದಿಲ್ಲ. ಇನ್ನು ಸ್ವಲ್ಪ ಓದ್ಲಿಕ್ಕಿದೆ ಅಂತ ಅನಿಸ್ತದೆ. ಹಾಗೆ ಈಗ ನಿಮ್ ಮಟ್ಟ ಈಗ ನಾವು ಕೇಳ್ಬೋದಾ? ಅಲ್ಲ ಅಂದ್ರೆ ತಯಾರಿಯ ಮಟ್ಟ ಹೇಳಿ. ಹಾ 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 ಅದು ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ಇರೋ ಕಾಪಿ ಇಷ್ಟು ಒಂಥರ ಸ್ಮಜ್ ಆಗಿದ್ದಾಗಿದೆ. ಹಾ 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 ಮಿಸ್ಟರ್ ಅರಿಗಾ ಈಸ್ ಅಲ್ಲ ಹಾಗಲ್ಲ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು. ಈಗ ನಿಮ್ಮ ಹತ್ರ ಇರುದೇ ಅವ್ರ ಹತ್ರ ಕಾಪಿ ಇರ್ಬೋದು. ಅವ್ರು ಹೇಳುದು can that not be checked, Krishna Swami, but from your office? ಅಲ್ಲಲ್ಲ ನಿಮಗೆ ಅಂದ್ರೆ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅಂದ್ರೆ ಮತ್ತೆ ನಿಮ್ಗೆ ಪ್ಯಾಸೆಂಜರ್ ಕವರ್ ಆಗುದಿಲ್ಲ. ಹಾ, ಹಾಗಾಗಿ ನೀವು ಅದಕ್ಕೋಸ್ಕರ ಯು ಮೇ ಹ್ಯಾವ್ ಟು ಗೋ ದಟ್ ಎಕ್ಸ್ಟ್ರಾ ಮೈಲ್, speak to, because it is his car. This is not some outsider, somebody truck or some such thing. It is only this. It is like Bacchus family, Bachhus, the Greek god of this. So Bacchus family ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಈ ಬ್ಯಾಕಿಂಗ್ ಅಪ್ ನೀವು ಕೇಳಬೇಕು ಅವರ ಹತ್ರ. Sorry, Krishna Swami, by that using matta, did I hurt you? Sorry. By using that expression, tayari matta sariyagide anta keliddu, did it hurt you? I will withdraw that. ಅಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ಮನಸ್ಸಿನಲ್ಲಿ ಸಿಟ್ಟಿಂಗ್ that I should not commit mistake. I should not go back with the evening. 1 minute. I should not go back with the feeling if I had asked this question with Krishna Swami, probably I would not have committed this mistake. And Krishna Swami is such a long standing counsel that I can't think of a better person to put a volley of questions. But whether I have committed any mistake in using that particular word, that was troubling me. ಅಂದ್ರೆ ನನಗೆ ಕ್ವಶನ್ ಕೇಳೋದು, ನನಗೆ ನಂತರ ನೀವು ಆನ್ಸರ್ಗೆ ಇಮಿಡಿಯೇಟ್ ಏನೋ ಸಮಸ್ಯೆ ಇದ್ರೆ ನನಗೆ ಹೇಳ್ಬೋದು. But Ariga, what he says is also correct. You are from same, you can find out from the owner, you are all traveling. No, your answer is a very plausible answer. Plausible. But not something, which can be pursued further. It can be pursued further by you because with common interest you went. It is not like a car was going and you paid some fair amount and went. That's a casual this thing. This was something more deeper. You went there with the common purpose. Accident liability ಬೇರೆ, ನೀವೆಲ್ಲ ಒಬ್ಬೊಬ್ರಿಗೆ ಗೊತ್ತಿರುವವರು. And now what is the solution? ಅಂದ್ರೆ ಅದು ಆಕ್ಟ್ ಪಾಲಿಸಿ ಅಂತ ನೀವು ಹೇಳೋದಾ, ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಅಂತ? ಮೇಡಮ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಆಯ್ತು. ನಾವು ಐ ವಿಲ್ ಗೋ ಬೈ ವಾಟ್ ಬೋತ್ ಆಫ್ ಯು ಸೇ ಫೈನಲಿ. ನಾವ್ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂದ್ರೆ ಇದೆಲ್ಲ ಜೆರಾಕ್ಸ್ ನೋಡಿ ಇಷ್ಟು ಇದಿದೆ. ಪಾಲಿಸಿ ಫಾರ್ ಆಕ್ಟ್ ಅಲ್ಲ ಇಷ್ಟು ಈಗ ಇಷ್ಟು ದೊಡ್ಡದಾಗಿ ಪಾಲಿಸಿ ಫಾರ್ ಆಕ್ಟ್ ಲಯಬಿಲಿಟಿ ಅಂತ ಇದೆ, ಅದನ್ನ ಸ್ಟ್ರೈಕ್ ಆಫ್ ಮಾಡೋದಾಗಿಲ್ಲ. ಹೀಟ್ ಹಾಕಿದ್ದು ಕೆಳಗಡೆ ಇದೆ. ಕೆಳಗಡೆ ಅಲ್ಲ. ಆಯ್ತು, ನೀವು ಪ್ರೀಮಿಯಂ ನೋಡಿ. ಅಂದ್ರೆ ಅದು ಆ ಟೈಮ್ನಲ್ಲಿ ಯಾವ ಇಸ್ವಿ? ಹೌದೌದು, ಆಯಾ ಕಾಲದ ತಾರೀಫು ಇವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ಇದೆ ಇದೆ ಇದೆ. ಹಾಗಲ್ಲ, ಈಗ ನಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಡೌಟ್ ಬಂದಾಗ ಆ ತಾರೀಫ್ ಏನು ಅವರು ಇದು ನೀವು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದು ನಿಮ್ಗೆ ಇಂಡಿಕೇಟಿವ್ ಅಲ್ವಾ? ಯಾಕಂದ್ರೆ ತುಂಬಾ ಕಡಿಮೆ ಇರ್ತದೆ. ಅಂದ್ರೆ ಸ್ವಲ್ಪ ತಾರೀಫ್ ಜಾಸ್ತಿ ಇರ್ತದೆ. ಇದೀಗ ಯಾವ ಇಯರ್ದಿದು ಪಾಲಿಸಿ? ದಿನ ಹೌದು 97ರಲ್ಲಿ ನೀವು ಜಸ್ಟ್ that they can tell you instantly.
ತಗೊಂಡಿದ್ದಾನೆ ಗಾಡಿ 97 ಅಂದ್ರೆ ಒಂದು ತಿಂಗಳು ಇನ್ನೂ ಆಗಿತ್ತು. ಒಳಗಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರ್ತಿತ್ತು, ಬೇರೆ ಓನರ್ ಇವರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ. ದಿಸ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಇಟ್ಸೆಲ್ಫ್ ಇಂಡಿಕೇಟ್ಸ್ ದಟ್ ಇಟ್ ಇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್.
ಸರಿ ಕೃಷ್ಣಸ್ವಾಮಿ, ಈಗ ಇವರು ಸಣ್ಣ ಡ್ಯೂರೇಷನ್ಗೆ ಇವ್ರು ಕೊಟ್ಟಿದ್ದ ಅಲ್ಲ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದ ಮೊದ್ಲಿಂದೆ? ಅಂದ್ರೆ ಇದರಲ್ಲಿರುವ ತೋರಿಸೋ ಮೊತ್ತ ಟೋಟಲ್ ಅಮೌಂಟ್ paid by way of premium is for the whole year, entire year. So you ask your their insurance officer, they will be able to say by looking at the chart of that year what this represents, whether this sum ಅದು ಹೌದು. ಆ ಅಮೌಂಟ್ ರೆಪ್ರೆಸೆಂಟ್ಸ್ ಪ್ಯಾಕೇಜಿನ ತಾರೀಫ್. ಹೌದು, ಆ ಪ್ಯಾಕೇಜ್ ಪಾಲಿಸಿಯ ತಾರೀಫ್ ಅದು ಅಲ್ಲ ಆಕ್ಟ್ ಪಾಲಿಸಿಯ ತಾರೀಫ್ ಅಂತ ಅವರ ಕೋಷ್ಟಕ ಅವರ ಟೇಬಲ್ ನಲ್ಲಿ ಗೊತ್ತಾಗ್ತದಲ್ಲ. ಅದನ್ನು ಕೇಳಿ. ದಿಸ್ ಈಸ್ ದಿ ಶಾರ್ಟ್ ಕ್ವೆಶ್ಚನ್. ಎಸ್ ಎಸ್ ಎಸ್. ಸೊ ವೆನ್ ಶುಡ್ ಐ ಟೇಕ್ ಇಟ್? Now only this is the question. The other question is two questions. One, whether it's act or comprehensive. The only indicator is whether this amount for that period represents premium for act or comprehensive. This amount is clear. Okay. Second is whether 1210 or 1150. You are relying only on that Anil Kumar's SCS entry. Anil Kumar gave the history in SCS hospital. ಏನಂತ? ಅದೇ 1210 or 1150. So there are only two questions. One is policy act or package. Two, whether accident is at 11:50 p.m. or 12:10. That is third Moorne Tarikh. Now you are placing reliance on exhibit R5. Exhibit R5 ಏನು ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರೇ? ಅಂದ್ರೆ ಪೊಲೀಸರ ಮುಂದೆನಾ ಯಾರ ಮುಂದೆ? ಪೊಲೀಸರ ಮುಂದೆನಾ? ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೈ ಅದೇ ಬೈ ಅನಿಲ್ ಕುಮಾರ್. ಕ್ಲೇಮೆಂಟ್ ಯಾವ್ದ್ರಲ್ಲಿ? 199 of 2000 MEC. He was examined as ಇದು ಎಕ್ಸಿಬಿಟ್ R5 ಸಿಗತ್ತಾ ಮೇಡಮ್? ಅನಿಲ್ ಕುಮಾರ್ ಇಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ. ಎಲ್ಲಿದೆ? ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ? ಇದರಲ್ಲಿ ಇಲ್ಲ. ಇಲ್ಲಿ ನಮ್ಮ ಫೈಲ್ ನಲ್ಲಿ ಬರೀ ನೋಡಿ, ಅವರಿಗೆ ಕೊಡಿ. ಐ ಥಿಂಕ್ ಇವೆಲ್ಲ ಕೇಸುಗಳು ಹಿಯರಿಂಗ್ ಆಗದೆ ಉಳಿದಿದ್ದೇ ಈ ಕಾರಣದಿಂದ ಇರಬೇಕು. ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ವೆರಿ ಅಂದ್ರೆ ಅತಿ ವಿಶಿಷ್ಟ ಸೇವಾ ಮೆಡಲ್ ಎಲ್ಲ ಇರ್ತದಲ್ಲ, ಪರಮವೀರ ಚಕ್ರ. ನೀವು ಯಾರಾದ್ರೂ ಒಂದು ನಾನು ಅದು ಹೇಳಿ, ಐ ನೀಡ್ ದಟ್. ಆ ಲೆಟರ್ನಲ್ಲ ಈಗ ಇದರಲ್ಲಿ ಕೊನೆಗೆ ಇಷ್ಟೆಲ್ಲ ಆಗಿ ಎಷ್ಟು ಅವಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಇದ್ರಲ್ಲಿ ಅಷ್ಟು ಇದರಲ್ಲಿ ಸ್ಮಜ್ ಆದ ಇದು ಕಾಣಿಸುದಿಲ್ಲ. ಅದನ್ನು ಬ್ಲಾಂಕ್ ಇಟ್ಟು ಟೈಪ್ ಹೊಡೆದಾಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಅದರ ಥಿಕ್ನೆಸ್ ಜಾಸ್ತಿ. ಇದ್ರಲ್ಲೂ ಅದೇ ಇದೆ. ಇದ್ರಲ್ಲಿಯೂ ಅದು ಸ್ಮಜ್ ಮಾಡಿದ ಏನು ಗೊತ್ತಾಗೋದಿಲ್ಲ ನೋಡಿ. ಬರೀ ಒರಿಜಿನಲ್ ಇದ್ರೆ ಮಾತ್ರ ಏನಾದ್ರೂ ಹೇಳ್ಬೋದು. ಒಂದು ಕೆಲಸ ನೀವು ಯಾರಾದ್ರೂ ಮಾಡಬಹುದು, ಒಬ್ರು ತಗೊಂಡು ಇದರದ್ದೊಂದು ಸಣ್ಣದು ಕಂಪೈಲೇಷನ್ ನೆಸರಿ ಬೇಕಾದ್ದು. ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ದಿನಾ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು, ಅದನ್ನ ಒಮ್ಮೆ ನಿಮ್ಗೆ ತೋರಿಸೋದು ಮತ್ ನಾನ್ ನೋಡೋದು. ನೆಸರಿ ಏನಿದೆ ಕಂಪೈಲೇಷನ್ ಕೊಟ್ರೆ that will help me. And this time gap is so narrow. Even to tell you frankly, unless such such unimpeachable material is placed, my mind is also disinclined to put it at 12:10. ಹೀಗೆಲ್ಲ ಇದ್ದಿದ್ದು ಆಗ್ತದೆ. ಮಾಡ್ತಾರೆ, ನಮಗೂ ಸಮಸ್ಯೆ ಆಗ್ತದೆ. ಇದು 10 ಓನ್ಲಿ that is one possibility. Second is, you see, in serious cases, FIRs will be transmitted to the court almost immediately. In 304A cases and all that, after 2 days it is taken. So that gap will be taken advantage. There is that possibility also, though I don't want to put before you all what we know about criminal.
Hospital authorities will move wound certificate and an undisputed point. Persons who had no knowledge with regard to the expiry of the policy.
No,
indication that
No. You see, for post-mortem, the practice is under the police manual. The doctor has to take the extract from certain document that is known as 148(1) and 2. There is form number in the police manual. You can check that. So in form number 148, 1 and 2, entries are made based on the entry in the FIR. So it is like that. The doctor who performs the postmortem examination will never speak to anybody. He will simply look at that and will make a copy. There is a postmortem register. In that he will make an entry, or he will ensure that that entry is made based on form number, these form number. So thereafter he will write his observation, notes of PME, that he is required to maintain. What they do, we don't know, but that is the requirement. They have Mysore government medical rules or something. There is 1967 or so. There is some rule based on which the doctor should do it. Police should send the forms under the police manual. So this man, doctor, follows his medical rules, 1967, which requires him to follow. So doctor does not independently check. Now this doctor in SCS hospital, I don't know, these patients who go with fractures will note so clearly 12, 10. ಮೂರು ಅಂದ್ರೆ ಒಂದೇ ಎಂಟ್ರಿಯಿಂದಲೇ 3 wound ಸರ್ಟಿಫಿಕೇಟ್ ತಯಾರು ಮಾಡೋದು. ಮೆಡಿಕಲ್ ಹಿಸ್ಟ್ರಿ ಒಂದೇ. ಅದೇ ಏನ್ ನಾ ಹೇಳ್ತೇನೆ, MLC ರಿಜಿಸ್ಟರ್ ಇರ್ತದೆ, ನಿಮಗೂ ಅದನ್ನು ಗೊತ್ತಿರ್ಬೇಕು. MLC ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಪೇಷಂಟ್ ಬಂದಾಗ ಯಾರು ಫಸ್ಟ್ ಅಂತಾರೆ, ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ಇದ್ದು ನೋಡ್ತಾರೆ. ಆ ಹಿಸ್ಟ್ರಿಯನ್ನೇ MLC ನಂತರದಲ್ಲೂ ಪೇಜ್ ಅಲ್ಲಿ ಆಸ್ ಬಿಫೋರ್ ಅಂತ ಬರೀತಾರೆ. ಅವನು ಎರಡೆರಡು ಸಲ ಪೇಷಂಟ್ಗೆ, ಡಾಕ್ಟರ್ಗೆ, whether what is important for him to do is to examine medically these patients or to go on making history.
Time is mentioned. Renewal is from 3:30. Therefore, validity is only for 50 days. You are educated to have the validity. Remain on fixed ಮಾಡಾದ್ರೆ ಪೇಂಟಿಂಗ್ ಆಗುತ್ತಾ ಅಂತ ಡೇ ರಾತ್ರಿ 12 ಗಂಟೆವರೆಗೂ ಕಾಯಬೇಕಾಗಿತ್ತು. ಮಧ್ಯಾಹ್ನ 3:30ಕ್ಕೆ ಹೋಯ್ತು ಮಾಡಿ. That document is accepted because the owner accepts that document. ಅದಕ್ಕೆ law decisions ನೋಡಿ
ಲಾಕಿ ನೀವು ಅವತ್ತು ಹೇಳಿದ್ರಿ SOBIN. ಅದೇನಿದ್ರು you read it to me and I also saw that it does not relate back to the previous 12 midnight, but the time mentioned. If no time is mentioned, then it will relate back to 12 midnight. 12 is the midnight. Para 1:08. Yes, sir.
2002 ACJ 6.3. This court has reiterated clear enunciation of law. Court observed that it is the obligation of the court to look into the contract deserve whether any particular time has been specified for commencement or expiry of the policy. A very large number of cases have come to our notice where insurance policies are taken immediately after accidents to get compensation in a clandestine manner. In order to curb this widespread history of getting insurance policies after the accidents, it is absolutely essential to clearly hold that the effectiveness of the insurance policy will start from the time of death specifically incorporated in the policy and not from an earlier point. view of our foregoing conclusion, these things have to be allowed to be ordered accordingly.
Yes. Is now this investigation we need to make only if the accident is proved to be shown to have occurred after 12 in the midnight. Exhibit R1.
And stated period 17, 11, 97, 3:30 PM. Very good clarity. Copy.
ಇದೊಂದು ಮೇಡಮ್ ಇದು ಭೂತ್ ಕನ್ನಡಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಮ್ಯಾಗ್ನಿಫೈಯಿಂಗ್ ಗ್ಲಾಸ್ ಅದನ್ನ ಇಟ್ಕೊಳ್ಬೇಕಾಯ್ತು. ಈಗ ಎಲ್ಲಿ ನೀವು ಟೈಮ್ ಎಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ, ಎಲ್ಲಿದೆ? ಇದರಲ್ಲಿ ಪೆನ್ಸಿಲ್ ನಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ, ಪೆನ್ಸಿಲ್ ನಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಕಾಣಿಸ್ತದ? ಟೈಮ್ ಎಲ್ಲಿ ಬರೀತಾರಪ್ಪ? ಹೌದು, ಅದು ನೋಡಿದೆ ನಾನು. 3 ಏನ ಎಲ್ಲ ಅದ್ರ ಮೇಲೆ ಕ್ರಾಸ್ ಬಿದ್ದಿದೆ. ಏನೋ ಒಂದು 3 ಆಗಿ ಕಾಣ್ತದೆ ಅಷ್ಟೇ. ಒಂದು ಪೆನ್ಸಿಲ್ ನಲ್ಲಿ ಬರೀರಿ, ಇದರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ ಅದರ ಅಡಿನಲ್ಲಿ. ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ. ಓ ಇಲ್ಲ ಅಲ್ಲ, ನಾನು I saw somewhere. ಅದು 3:30 17/11/97 ಇಂದ ಶುರು ಆಗೋದು ಅಂತಲ್ಲ, ಕಾರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅದು ಆ ಟೈಮಿಗೆ ಇರಬೇಕು. ಮತ್ತೆ ಇದು ಆಕ್ಸಿಡೆಂಟ್ 2:12 ಆಗಿದ್ದು 3:30 PM 17/11 ಶುರು ಆಯ್ತು. See, no, Krishna Swami, it may not be proper. For example, this policy of insurance was taken by some X. So, as per the policy issued by you to this car, it was to end on 2/12/97 at 12 in the midnight. Fine. Now, this man got the policy transferred at 3:30 PM on 17/11. So, commencement, yes. Ending should be as per the previous contract, because it is for the remainder period. No, Krishna Swami. He did not take it independently from you. No, then where have you said the ending is at 3:30?
Ending Supreme Court commencement or ending deserve not just before.
Now, I want to ask you 2 questions. Don't say you can't answer. See, the policy was taken, which was to end by the original owner, end on 2/12/97 at 12 in the midnight. Fine. Now, what is the rule regarding transfer? When it takes transfer, the time, ending time gets cut down because this man gets the transfer at some particular day. Does it get cut down automatically?
Expiry was by midnight. Insurance company not out to pay. Question of the time of commencement of risk.
Now, 1 minute. You are not only one-sided. You are 1 minute. Well, he has only taken transfer of the policy. So, transfer of policy is mentioned with effect from the transfer time. Naturally, if he had purchased at particular point of time, he could not have asked for some other time, well, in the midnight or whatever. But ending will be as per the policy only.
Renew the policy for a period of 15 days.
Then you should have, you see, you had issued the policy for this car till 2/12/97, 12 in the midnight. You had issued the policy. Then only supervening circumstance that has taken place is the purchase of the car by this fellow, Harish Shetty. 1 minute. You had collected the premium for entire 2/12/97, 12 in the midnight. This man had only purchased, therefore he did not put the additional burden on you. He had purchased the car. So the beginning commencement time, so far as this new owner is concerned, will be the real time. But ending time will not get shortened by a few hours. Why in the... Okay, I understand.
Because of the original policy of insurance was also commenced at 3:30 or not. Therefore, the original policy.
No, fine. This is R1. One minute. So that you don't dispute. The policy before purchase was to end at 12 in the midnight on 2/12. All 3. 330 ಒರಿಜಿನಲ್ ಇದ್ರೆ ಇವರು ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಂಡಿದ್ದು no, that does not follow as a then you produce that original or copy which you are having. ಅದು ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದೆಲ್ಲ ಮತ್ತೆ ಅಂದ್ರೆ the trend of the decisions suggest that it is your duty. ಬರ್ಡನ್ ಎಲ್ಲ ನಿಮ್ ಆಯ್ತು, ನೀವು ಸ್ವಲ್ಪ ಎಫರ್ಟ್ ಮಾಡಿ. ಸರಿ, ಇನ್ಶೂರೆನ್ಸ್ ಇಂದ ಮಾತ್ರ ನಿಮ್ಮ ಮೇಲೆನೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆಯ್ತು, ನೀವು ಅದನ್ನು ಫೈಂಡ್ ಔಟ್ ಮಾಡಿ ಒಟ್ಟಿಗೆ ಅದನ್ನೊಂದು ಪಾರ ಟಿಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲ, ಈ ಪೇಜ್ 36 ಅದು ನಾವೇನು ಅದನ್ನು ವಿ ಕಾಂಟ್ ಹೋಲ್ಡ್ ಇಟ್ ಅಗೇನ್. As far as owner is concerned, with regard to this levy, that is not challenged by the owner. The claimants also have not challenged. No, not so far as he is concerned. That goes against the principle of res judicata. That goes against well-established principle. That doesn't bind him. ಹೇಳಿರ್ಬೋದು, ಬಟ್ ದಟ್ ಈಸ್ ನಮ್ಮ so far as he is concerned, it doesn't affect him. If the owner comes here, you can shut his mouth by saying you have not questioned, that has become final, because it is judgment inter partes between him. So far as he is concerned, he has kept the matter agitating. He has kept the matter. He has taken it in appeal. He is not an appellant before me. He is not appellant before me. Therefore, so far as claimants are concerned in this, the matter has not reached finality. That is what the principle of law says. Right? Right? ಈಗ ನೀವು ಫೈಂಡ್ ಔಟ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ದಲ್ಲ. I suggest no, not satisfaction for the purpose of this case only. Otherwise, there should not be any appearance that I am getting too many doubts. For the purpose of this case. I move my head to that last submission of yours. Unfortunately, this is not ending. But if the cause of justice requires, ಸ್ವಲ್ಪ ಹೊತ್ತಾದಾಗ ಆಗ್ತದೆ ಅದು. Mr. Prashant?
Yes, my lord. My lord, I have gone through the judgment. Says that, my lord, paragraph number 18, my lord, is relevant. In Ramchandra case, my lord.
ಇದ್ರಲ್ಲ ಹೌದೌದು. It should be clear. First of all, every interpretation should be based on the terms of that policy, because it's a contract. ಆಗಲ್ಲ. Mr. Krishnaswamy, you are not thinking on practical lines. There are cases where it becomes impossible for the claimant to persuade the owner to produce it. Sometimes they don't care. Yen provision idru, what he can do? This is the problem. Faced with the practical problems, Supreme Court or the High Court have gone on putting all kinds of burdens on the insurance company. Pay and recover. Why this pay and recover? Because some justice is required. This is a social security kind of measure. A person loses the breadwinner in the family. Otherwise, can the government generally go on issuing ex gratia compensation? No. So somebody is collecting some amount for all the vehicles which are running on that's the supposition under law, flying on the road. So let us fix the liability on him. You may have your own grievances, but we have some little justification. You have grievances. But for this specific issue, that is any hurt, bodily injury or personal injury or death taking place on road. ಮಾತ್ರ ಒಂದು ಆಫೀಸ್ ಕಾಪಿ ಇರ್ತದಲ್ಲ, ಅದನ್ನಾದ್ರೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ. Where the vehicle is shown to have been involved in the accident, the courts have found a way out what to do. Then let us ask the insurance company, which at least says, yes, I have issued the policy cover. Then you please produce. Now at least see, beyond 2010, 2012, computerization has set in. Now you can't be heard to say that I have this difficulty, I have that difficulty. Available. ನೀವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರ್ಬಾರ್ದು. ಅಂದ್ರೆ ನೀವಂದ್ರೆ ಕೃಷ್ಣಸ್ವಾಮಿ ಅಲ್ಲ, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. When I say you, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂದ್ರೆ ಪ್ರಾಕ್ಟಿಕಲ್ ಏನೋ ಒಂದು ಸೊಲ್ಯೂಷನ್ ಕಂಡು ಹಿಡಿಬೇಕು. Yes, 18, Prashant.
Milad, with regard to that aspect, Milad,
don't you think this is against you?
Milad?
Now, ನಿಮ್ಮ ಪಾಲಿಸಿ ಇದರಲ್ಲಿ ಪಾಲಿಸಿ ನೀವು ಇಶ್ಯೂ ಮಾಡಿದ್ದಲ್ಲಿ ನೀವೇ ಹೇಳಿ. ನೀವು
that is what, Milad. I will once again.
ನೀವು ಈಗ ಓದಿ ಹೇಳಿದಲ್ಲಿ from what you have read out, it is apparent that it says MV liability.
That's what, Milad. That's what that was my, except so far as is necessary to meet the requirement of the Motor Vehicle Act, the company shall not be liable in respect of death or bodily injury to any person in the employment of the insured arising out of and in the course of employment. No,
so under the MV Act, then even if he is an employee, you have to cover.
That is what, my lord. It is necessary, my lord, to look into the, my lord.
Then the computation will not be based on WC Act.
No, my lord. That's what, my lord. No, in view of that clause, my lord, of policy terms, it is necessary to look into the, my lord, the requirement of policies in section 147. Your lordship, I can't see the 147. That is requirement of policies.
Sir, now tell me, what is the, you show me from your policy that what is the premium you have collected? From your policy, you show me.
My lord, the first
you
page,
read me, that section you have already read me.
my lord, first page of the policy, no? In my additional document, which is produced along with IA. But the right hand side, my lord, the liability. But the basic TP cover.
What is this TP?
But third party cover.
Third party cover. Yes.
Cover. And my lord, for driver, owner driver, we have collected 100 rupees. For paid cleaner, my lord, we have collected 25. For paid driver, my lord, we have collected 25 rupees. These are the, my lord, 4 items we have collected. We have not collected any premium towards coolies, my lord. It's only about driver, paid driver, and cleaner, and owner driver. These are the, my lord, 4 things. My lord, left hand side is with regard to own damage. That is not required to, my lord, for the case on hand. This is the, my lord, the premium schedule.
Yes. Now you are bound by IMD 40, 28, 39, 21.
Yes, that is what, my lord, premium collected.
What does this IMT 40, IMD 28, 39, and 21 say?
Well, then it is necessary to.
Does it deal with any this aspect, or it doesn't?
Only this aspect, whatever the premium you have collected shown, as with regard to owner driver.
Now, what do you say, madam, on this? He very clearly shows, only 2 sentences, not lengthy argument on this. He very clearly shows from this premium collected sheet that it is only for paid driver, paid cleaner, and owner driver. Only that. Nobody else premium has been paid by you. Not by you, by the owner. You rely. But that judgment also says contract should be looked into, and the court should very carefully peruse that and then act on that. If you must submit, if you have anything else to say beyond what he has said, that's the end, because this is not a place for talking shop alive. We sometimes suffer from this misconception. For everything, all things need to be. No. ಇಷ್ಟೇ ಅವರು ನೀವು ಕೊಟ್ಟಿದ್ದು ಅಂದ್ರೆ ನೀವಲ್ಲ, ಅವರು ಕೊಟ್ಟಿದ್ದು ಇಷ್ಟೇ ಇವರು ತಗೊಂಡಿದ್ದು. ಸೊ ರಾಮಚಂದ್ರ ಆಲ್ಸೋ ಡಸ್ ನಾಟ್ ಡಿಪಾರ್ಟ್ ಫ್ರಮ್ ದ್ಯಾಟ್. ಏನಾದ್ರು ಸೆಂಟೆನ್ಸ್ ಇದ್ರೆ ಹೇಳಿ, ನಾಟ್ ಲಾಂಗ್ ಆರ್ಗ್ಯೂ. Supreme Court in Ramchandra says, sweeping general, where are you looking? I am here. He is not on the division bench now, right now. However much I would have liked him to be there because of his expertise. President has thought otherwise. They are drivers and cleaners. Drivers and cleaners. ಅಲ್ಲಿಂದ ಇಲ್ಲಿ ಎಲ್ಲ ಹೋಗ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. The short question that arises for consideration in this appeal at the instance of the appellant, at the instance of the insurance company, is as to whether in a case where the policy of insurance issued by the policy of insurance issued, the premium collected is only for the paid driver, owner driver, and the cleaner, insurance company could be held liable to pay compensation for the bodily injury or the death of a coolie in a heavy goods vehicle beyond, above and beyond the compensation payable for such death under the Workmen's Employees Compensation Act 1923. Beginning with the question.
Questions that arise for consideration in this appeal of the instance of the
in a petition.
in this
ಅದರಲ್ಲಿ ಒಂದು 166 ಅಲ್ಲ ಇದು ಪಿಟಿಷನ್ 166 ಏನು
166
ಅದು ನಂತರ ಹಾಕೊಂಡು the facts lie in a narrow compass, full stop. One Mutturaj is the claimant. The allegation is that he was proceeding in heavy goods vehicle bearing registration number KA-20A5075, which met with an accident resulting in injuries, grievous injuries to the claimant on 3/6/2009 at about 10:30 p.m. Full stop. The policy coverage is not in dispute, but so far as liability is concerned, Planet Counsel for the insurance company, by filing IA number estado additional document IA number 1 of 2015 has produced the policy of insurance along with the relevant attached sheets to the same with the consent of ಅದನ್ನ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಅಲೌ ಮಾಡ್ತೇನೆ ಯಾಕೆಂದ್ರೆ ಅದನ್ನು ಯಾರಾದ್ರೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲೇಬೇಕು.
That application came to be allowed on 27/2/2016, Malad.
The said application has already been allowed on
22/2/2016.
Full stop. Therefore, document is required to be considered for the purpose of deciding this appeal. Next one. The next one. Insofar as the liability under the policy of insurance is concerned, it is necessary to extract the relevant entries in the same. ಇದು ಇಲ್ಲಿದೆ ಮೇಡಮ್, ಇದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ಗೊತ್ತಾಗಿಲ್ಲ. You have not filed their liabilities, yes, but I don't have the jurisdiction under MV Act. If you file, I can do that. You are not done. But claim can be restricted. Interest can be granted by only that tribunal, not by this tribunal. This appeal is coming from that. If you want to settle, you can settle by agreeing. They may agree also. I don't know. Now they are having all the aces up their sleeve. You have argued. You should have considered that and made a settlement with them, saying rest I will claim against the owner, which you could have done. You follow? Oh, I don't have the jurisdiction to grant their liability, yes. But then you should have knocked those doors. ಏನ್ ಬಂದ್ರಿ
Insofar as a liability under the policy and insurance is concerned, it is necessary to extract the retained interest.
In the policy stuff, it reads as follows. Next paragraph. The learned tribunal, after inquiry, has allowed the claim petition in part, awarding a compensation of
2,80,610.
ಅದು ನೋಡ್ಕೊಳ್ಳಿ ಆಯ್ತಾ. 1805 ಇಂದದು of 2010. With interest thereon at how much percent?
6%.
6% per annum from the date of the petition till the date of payment. Next part. 8%. Interest at the rate of 8% per annum from the date of the petition. That I will maintain. That I will maintain. From the date of the petition till the date of payment. Next part. Learned counsel Sri H.N. Prashant for the appellant insurance company contends that the liability of the insurance company, insofar as the personal injury suffered by the claimant, who was admittedly traveling in the insured vehicle as a coolie, is concerned, limited to the extent of the compensation payable under the Employees Compensation Act 1923 and nothing more. For the said purpose, he full stop. He therefore submits that the learned tribunal was in error in fastening the entire liability to pay the compensation on the appellant insurance company, and therefore the judgment and award impugned herein is liable to be modified to the said extent, and the liability of the appellant is required to be reduced. Next part. Learned counsel for the respondent claimant per contra submitted that in view of the decision of the Honorable Supreme Court in Ramchandra No. I was having that. Ramchandra versus United India Insurance Company Limited, within bracket AIR 2013 Supreme Court 2561. This court is required to look into the terms and conditions of the policy issued, and on such perusal, the appellant insurance company is liable to pay the entire compensation, and its liability is not limited to the extent the compensation is payable under the Employees Compensation Act 1923. She therefore submitted that there is no merit in this appeal and it is liable to be dismissed. Next part. Perusal of the judgment and award impugned herein shows that ಈ legal aspect ಅವರು consider ಮಾಡಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ ಸರ್, ಮಾಡಿಲ್ಲ.
Shows that even though it has even though the learned MACT has meticulously scrutinized the evidence placed and assessed the compensation payable by applying relevant principles guiding the same.
The court is not audible, my lord.
You will get the corrected copy. You can read that. The above clearly shows that the owner had paid a premium to cover the risk of the owner driver, paid driver, and a paid cleaner, and not beyond the same. Full stop. Therefore, under the contract of insurance entered into between the owner of the offending vehicle and the appellant insurer, the liability to pay compensation under the MV Act is only to the driver, owner driver, paid driver, and paid cleaner. Full stop. The claimant being a coolie in the lorry, therefore, he is entitled to claim compensation from the claim compensation. Sorry, full stop. The insurance company, therefore, has limited its liability insofar as its statutory liability to the coolies on the insured vehicle is concerned, to the extent of the liability arising under the Employees Compensation Act 1923. 147 ಯಾವ್ದ್ರಿ ಅದು?
147 ಪ್ರೇಮ್ ಭಾಯ್ ಪಟೇಲ್ ಕೇಸ್ ಮೇಡಮ್.
147 ಅಲ್ಲೇ ಓದಿ ಹೇಳಿದ್ರಲ್ಲ.
147
ನೀವೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಮೇಡಮ್. ಇನ್ನು ಬೇರೆ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ, ಇದೊಂದೇ ಅಲ್ಲ, ಮತ್ತೆ ಇನ್ನ ಅದನ್ನು ಇನ್ನೊಬ್ರು That's necessary. This is a question. That's why I said it's a question of law. The question when necessary facts are available here. That's why I have mentioned. You have not followed.
Para 11, 12 and 13 of the Malad.
The above position is very clear from a close reading of section 147 of the Motor Vehicle Act 1988. The proviso small Roman 1, proviso small Roman 1, 2, clause B. Subsection 1 of section 147, under 147 within bracket 1, B, proviso 1 reads as follows: provided that a policy shall not be required, reads as follows, full stop. The Honorable Supreme Court in Ramchandra's case, Supra, has only said that the court adjudicating the matter will have to closely scrutinize the terms and conditions in the policy issued in each case, and thereafter determine whether additional premium has been collected under the policy of insurance to cover the risk of a coolie in a goods vehicle above and beyond the liability under the Employees Compensation Act 1923. As already noticed, in this particular instance, the policy of insurance clearly discloses that no additional premium was collected to cover the risk of the coolies on the offending vehicle by the appellant insurance company. Therefore, it is axiomatic that the liability of the appellant to pay the compensation remains confined to the extent the same is awardable under the Employees Compensation Act 1923. Plenary Tribunal has held that the claimant was aged 21 years at the time of the accident. The accident has taken place in the year 2009. Therefore, the maximum notional income that can be taken under the Employees Compensation Act 1923 is rupees 4,000, and accordingly, the notional income of the claimant is fixed at rupees 4,000 per month. The Plenary Tribunal, upon detailed consideration of the medical evidence, has come to the conclusion that the functional disability resulting in loss of income for the claimant is 20% to the whole body. The relevant factor applicable to the case of the claimant, he being aged 21 years at the time of the accident, is 222.71 under the Employees Compensation Act 1923. Therefore, the compensation awardable under the Employees Compensation Act is rupees 4,000 into 60 by 100 into 222.71 into 20 by 100. Alright?
But may I make one submission? 4,000 is the maximum amount, and in the injury case, 60% of 4,000 rupees to be considered.
ಅದನ್ನೇ ಹೇಳಿದ್ನಲ್ಲ ನಾನು.
Please.
60%, 4,000 into 60 by 100 into 222.71 into 20 by 100. Is that correct?
Yes, correct.
ಅದು ಎಷ್ಟು ಬರ್ತದೆ ಲೆಕ್ಕ ಹಾಕಿದ್ರಾ?
1,06,900 ಬರುತ್ತೆ.
Now she says interest should be paid as payable by the workman compensation commissioner. I have little doubt on the proposition. Now, why not grant 12%? But if you ask for my finding, it may become difficult for me, because I am not hearing an appeal from the Workmen Compensation Commission, and the power to grant interest, I can grant little more than 6%, but whether that provision on payment of interest.
My respectful submission is that, my lord, when I said that, my lord, my liability is restricted to WC Act, but entire the provision of WS Act will automatically apply to the facts of the case. So 12% from 1 month from the date of accident is required to be, my lord, ordered.
Good. Good job. Similarly, on the compensation so computed, similarly, since the liability of the insurance company to pay the compensation is limited to the extent payable under the Employees Compensation Act 1923, the interest payable should also be calculated under the same enactment, and consequently the interest payable is at the rate of 12% per annum from 30 days from the date of the accident till the date of depositing the amount. Full stop. The appeal is allowed to the said extent. The amount in deposit shall be transmitted to the learned court below forthwith. Excess amount ನೀವು ಎಷ್ಟು ಜಾಸ್ತಿ ಮಾಡಿದ್ದೀರಲ್ಲ?
ಇಲ್ಲ, ಜಾಸ್ತಿ ಮಾಡಿಲ್ಲ. I have deposited 1,44,000 and 25,000, around 1,70,000 I have deposited. So ಜಾಸ್ತಿ ಏನು ಬರಲ್ಲ. I have to deposit the balance amount.
So the balance amount shall be deposited by the insurance company before the learned MACT within ಎಷ್ಟು time?
6 weeks from the date of receipt of the order.
Within 6 date of receipt. Transmit the records ಎಲ್ಲ ಮಾಡಿದ್ವಿ. Okay.
Much obliged.
Number 83, Suresh Amlatur.
For the appellant, my lord.
And for the respondent in this case, my lord.
My lord, there are two connected matters.
They are listed or not listed?
Connected matters, my lord.
No, ಅದು ಇವತ್ತು ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇದೆಯಾ ಲಾತೂರ್ ಅವರೇ? ಇಲ್ವಾ?
ಇದೆ ಸರ್. ಎಸ್ ಎಸ್, ಇಟ್ ಇಸ್
ಆಯ್ತು ಹಾಗಿದ್ರೆ ನೋಡ್ತೇನೆ. ಇದೆ ಒಂದೇ ಇರೋದಲ್ಲ.
83 ಸೀರಿಯಲ್ ನಂಬರ್ 83 81.
You are appellant in both.
In both the cases, my lord.
Seeking only enhancement or liability is only on the owner?
No, my lord. In this case, both the claim petition have been dismissed by the tribunal, my lord. It is a collision of two vehicles, my lord. The claimants are the occupants of a car. The petitioner is
the car driver.
One is the car driver and another one is occupant of the car, my lord.
Charge sheet is against whom?
Against the car driver, my lord.
What I am asking. So act policy.
Yes, my lord. It is a third party insurance we are claiming, my lord.
Can you give some citation supporting your argument?
Yes, my lord, I have produced the citations. About 6 citations have been produced to this court.
That's right.
So far as the negligent act is concerned, the first decision is irrelevant, my lord.
Mr. Rishabhendra.
My lord, can I submit, my lord?
Yes, sir.
My lord.
What on that legal this thing? He says.
My lord, in this case.
ನೀವು ನನ್ನನ್ನು ಸ್ವಲ್ಪ ಕೇಳಿದ್ರೆ ನಿಮಗೆ ನನಗೂ ಅನುಕೂಲ ಆಗ್ತದೆ. ಅವರು ಆಕ್ಟ್ ಪಾಲಿಸಿ ಹೌದಂತಾರೆ. ಆಕ್ಟ್ ಪಾಲಿಸಿ ತಾನೆ
ಸ್ವಾಮಿ ಈ ಕೇಸಲ್ಲಿ my lord the first response my lord the appellant in 2051 is the driver of the car in question. My lord, he dashed against a lorry. He has filed a claim petition under section 166 of the Motor Vehicle Act. Most important point, my lord. Second point, my lord.
ಎಲ್ಲ ಆಯ್ತು, ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಾನು ಇಲ್ಲಿ ತನಕ ಅವ್ರ ಹತ್ರ ಕೇಳಿದೆ. ಅಂದ್ರೆ ಅದು ಅವರು ಟಾಟ್ ಸೀಸರ್ ಅಂತ ನೀವು ಹೇಳೋದು ಅಲ್ವಾ?
And also he has filed a writ petition against this order of the my lord. He has filed a writ petition in WP number 10,644 of 10. My lord, that writ petition has been dismissed on 19th April 2010, my lord. My lord, it is very clear. Page number 3, having regard to the fact that evidence set on in the question, when the matter is set down for the arguments, the question of entertaining the application under section 163 of the Act does not arise. Hence, the writ petition is rejected. One more point, my lord.
ಈಗ ನಾನು ನೀವು ಫೈನ್ ಅವರು ಒಂದಷ್ಟು ಡಿಸಿಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ನೋಡಿದೀರಾ?
ಇಲ್ಲ, ನೋಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಅವರು ಹೇಳೋದು ಎಸ್ ಇಟ್ ಇಸ್ ಆಕ್ಟ್ ಪಾಲಿಸಿ ತಾನೆ.
No, my lord. I do not have a policy here, my lord. He dashed against our lorry.
Sir, I am not able to get any help from you.
My lord, he has filed a claim petition under section 166 of the Motor Vehicle Act, my lord.
That I heard you saying, I have absorbed that. I have clearly absorbed that point of your submission.
Yes, the petitioner himself has been charge sheeted by the police against him, my lord.
That he admitted.
Yes.
Secondly, my lord, yes, under section 166, he has to prove the negligence of the other vehicle, my lord, offending vehicle, our insurer. He has proved that.
His submission, Mr. Rishabhendra, is that he is claiming he is a third party. Whether such a contention is tenable, tenable under law.
No, my lord.
Why? He says 6 decisions support him. My simple question to you is whether you have gone through these decisions, number one. If you have gone through, whether they support the point of submission he is making.
Yes, my lord. My contention is this, my lord.
Sir, have you gone through these decisions?
No, my lord. I have not received the copy of the decisions, my lord.
Mr. Lathur, why you have spent so much time without giving a copy to him?
Copy. I'm sorry, my lord. I have not given the copies, but.
My lord, in this case, my lord,
sir,
the tribunal after the trial, along with the evidence has been adduced by the petitioners, is the claim petition as it is not maintainable. Page number 12 of the judgment, my lord. It is very clear. The charge sheet, the claimant himself, the petitioner himself is the driver and who dashed against a lorry, oncoming lorry, and he has been filed charge sheet against him. And he admits that he has not challenged the charge sheet and first information report filed against him. Page number 11 of the judgment, my lord. It is very clear. The trial court, after appreciating all the materials on record, dismissed the claim petition. In the frag end of the stage of argument, he has filed a writ petition that he has not disclosed.
Yes, this ACJ 2013-2544,
Yes,
which is the relevant para, Mr. Latur?
12, my lord.
Para 12.
Para is 12.
Just read that.
The same facts of the case are involved in this case also.
Sir, which is the relevant?
Para 12, my lord.
Is a beetle shop owner. Please read that.
Yes, PW3 was a beetle shop owner whose shop is situated near the spot of the accident. Though he was not examined by the investigating officer in the police case, he is examined before the tribunal whose evidence is required to be accepted for the reason that the same is not rebutted by the respondents. PW4 has stated in his cross-examination that he saw the accident from a little distance from the marketplace, where about 10 to 20 persons were present. He has further deposited that the truck was in a high speed and the people traveling in the car sustained injuries, and the driver of the car, Sushil Root, suffered grievous injuries and succumbed to the same. He was conscious when he was taken to a Jaipur hospital.
Charge sheet is against whom?
Against my driver, my lord. Against the petition in.
Where do you get that?
Chand Pasha.
ಅಲ್ಲಪ್ಪ ಅದಲ್ಲ ನಾ ಕೇಳ್ತಾ ಇರೋದು ಇದರಲ್ಲಿ ಈ ಡಿಸಿಷನ್ ನಲ್ಲಿ
ಈ ಡಿಸಿಷನ್ ದಲ್ಲೂ ಸಹಿತ ಸೇಮ್ ಹಂಗ ಇದೆ ಸರ್. ಅದಕ್ಕೆ ಐ ಆಮ್ ರೀಡಿಂಗ್ ದ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್.
ಬೇಡ, ನೀವು ವೃಷಭೇಂದ್ರ ನೋಡಿ ಕಾಪಿ ಕೊಡಿ, ಆಮೇಲೆ ಬೇಡ ಅವ್ರಿಗೆ ಕೊಡಿ ನೀವು. Learned counsel for the appellant to furnish these citations to see Vrishabhendraya, learned counsel appearing for the insurance company. ಈ M.E. ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ ಅವರ ಯಾರಿಗೆ R1 ಈಗ?
H. ಮಂಜುನಾಥ್.
ಏನ್ ಕೃಷ್ಣಸ್ವಾಮಿ ಇಲ್ಲಿ ಇದ್ದೀರಲ್ಲ ಈಗ, ನೋಡಿ ಅಲ್ಲಿ ಹೊರಗಡೆ ಇದ್ದಾರ. ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ, ಅವರ ಮೊಬೈಲ್ಗೆ ಒಂದು ಕಾಲ್ ಮಾಡಿ, ಅದು ಗೊತ್ತಾಗ್ತದೆ. Please call him. Anyway, he is there. Appeal. ಅಲ್ಲೇ ಇದ್ದಾರಾ? Is he containing insurance company containing this a false case? Being any police notice. Who is appearing for the specified Wakala Constable will first respond.
And even appointment delayed. Suggestion that he appointed the petitioner counsel as his advocate in the criminal case for releasing the vehicle. All these things have been considered by the police. They say that there is some verification of the vehicle. And examine the design.
3 is PSI Iona. Now RW1 is the owner.
Where also he has given clear admissions that he did not check any of the criminal court records. It is only the allegation of the airport advocate who represented the respondent to by the amended application before the trial court. It is not their case that initially they are present with the investigation report.
Exhibit P7 ಏನಿದು? P7. Statement. ಯಾರ ಹತ್ರ ಹೇಳಿದ್ದದು ಸ್ಟೇಟ್ಮೆಂಟ್? ಅಂದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರಿಗೆ ಕೊಟ್ರು ಅಂತ? ಹೌದ್ರಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾರ ಮುಂದೆ ಮಾಡಿದ್? ಪೊಲೀಸರ ಮುಂದೆನಾ?
Where the entire case of the respondent to
ನಿಮಿಷ. Mr. Maheshwar, kindly see whether Krishna Swami is there. One ನಿಮಿಷ. Which para you want to read? RW2 evidence ಓದ್ತೀರಾ?
You know the benefits of written statement of I am not signated to the written statement and going back to as claimed on it. At present, I am serving in regional office. We have appointed one investigator by name Chandan Nagaraj. I am not produced the said investigation report.
Right.
It is say that I have made false allegation as per paragraph 86 of my affidavit only on imaginary basis and not based on any investigation. I can produce the investigation report. I have gone through the investigation report. It is false to suggest that no investigator has been appointed and no report is there. Policy is admitted. I have not gone to the Karnataka police station in connection with concerned crime number. I do not know where the concerned criminal case is pending and I have not done there. Other document tamper agide ante helತಾರೆ. ಅಲ್ಲಿ tamper agide ಅರ್ಜಿ ಆಗಿದೆ. I have not seen the original record of the criminal proceedings which are produced here. I have not filed any application before the criminal court for the correction of exhibit R5 of the case. And these are advocate for the respondent number 1 for the magistrate court. And they say that the document R5 for a moment you are not the R5 document where one advocate named Tejaraj is appearing, who is the counsel in the claim petition also. And CCA is mentioned. This CCA means what? Nowhere it is disclosed or class examined to the PW. I do not know where the concerned people go. I have not filed any application R5. I know one advocate Chikanna had represented petitioner earlier in this case. It is false to suggest that one advocate Tejaraju appearing for respondent number 1 in this case was represented the accused in criminal case. This is not important. Now I see R5 and R5. This R5 is the original wakalat in the claim petition. The address of service is different and name and enrollment number also different. Signature on R5 is straight out. It is not my signature on R15. I do not know whether FIR is registered on the basis of R15 and was there any investigation or not. It is false to suggest that since it is a false complaint, no investigation was done. It is true to suggest that signature on R10 is not that of respondent number 1, but one Pavitra has signed on as a history of. It is true to suggest that address of respondent number 1 is shown as 13 in the policy R8, the exhibit R8 and exhibit R10. It is shown as 1/3. It is true to suggest that we have not given the proper address. Notice is not at all served on the respondent number 1. Our respondent number 1 ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು. respondent number 1 address ಸರಿಯಾಗಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿ. I do not know whether we have cross-examined the respondent number 1 on 16/4/2010. There was no difficulty for us to get the certified copy of criminal court record after receipt of notice from this court. Subsequent ಆಗಿ RW ನ ಕ್ರಾಸ್ ಮಾಡಬೇಕಾದ್ರೆ ಇವರು ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ, ಅವಾಗ ನಮಗೆ ಇದೆಲ್ಲ ಗೊತ್ತಾಯಿತು ಅನ್ನೋ ತರ ಕೂಡ ಅವ್ರ ಸ್ಟೋರಿ ಇಲ್ಲ. It's false to suggest that there is a difference in the signature in R6 and R40. That is also difference is there. It is false to suggest that it is not the signature of the petitioner's sponsor R6 exhibit R6. It is true to suggest that charge sheet is against one Balegoda. ಅದನ್ನು ಕೂಡ ಲಿಯೇಷನ್ ಮಾಡ್ತಾರೆ, ಬಾಳೆಗೋಡ ಅಲ್ಲ ಬಾಳೆಗೋಡ. ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಒಂದು ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ರೌಂಡ್ ಮಾಡ್ತಾರೆ. ಇದು ಅನ್ನೋನ್ ಪರ್ಸನ್ ಮೇಲೆ FIR ಆಗಿರುತ್ತೆ. ಅದಾದ್ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ನಲ್ಲಿ ಅದನ್ನೊಂದು ಸ್ಟ್ರೈಕ್ ಔಟ್ ಮಾಡಿ ಬಾಳೆಗೋಡ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದು ಕೂಡ ಅವ್ರ ಪ್ರಕಾರ ವಿಟ್ನೆಸ್ ವಾಲಂಟಿಯರ್ಸ್ ದಟ್ ಬಾಳೆಗೋಡ. We have not challenged the charge sheet. It is false to suggest that I am reposing falsely by producing all false documents to escape from the liability. ಯಾರು R1 ಅಲ್ಲಿ ಕ್ರಾಸ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ R1 ಡಿಲೇ ಮಾಡಿದ್ರು. ಇವರು ಅಪಾಯಿಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಕೂಡ RW1 ಅಲ್ಲಿ ಲಾಸ್ಟ್ 4 ಲೈನ್ಸ್.
ಥ್ಯಾಂಕ್ ಯು ಮಿಸ್ಟರ್ ಮಹೇಶ್ವರಪ್ಪ.
RW1 ಅಲ್ಲಿ ಲಾಸ್ಟ್ 4 ಲೈನ್ಸ್. I gave wakalat to one Tejaraju advocate. I cannot identify the signature of said advocate Tejaraju. It is false to suggest that
Yes.
one advocate by name Chikanna has filed wakalat for me in criminal case.
No, you want only enhancement, isn't it? ಮತ್ತೆ ಇದೆಲ್ಲ ಯಾಕೆ? ಅವ್ರು ಹೇಳಿದ ನಂತರ ಅದನ್ನು ಹೇಳ್ಬೋದಲ್ಲ. ನನಗೆ ಅರ್ಥ ಆಗದೆ ಇದ್ದಿದ್ದೆ ನೀವು ನಿಮ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆದಾಗೆ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಇಲ್ಲ ಅದೇ ಹೇಳಿದ್ದು ಇದು
My lord, court is muted, lord. Court
Court is
mute ಆಗಿದೆ.
muted.
ಈಗ can you hear me?
Yes, my lord.
You can hear me.
Yes, my lord.
There is some problem, I think, because of the service providers issue.
Network problem, yeah.
It is doing some kind of on and off.
Yes, my lord.
Light is blinking from the screen. That's why I switched off to avoid trouble. Whether at your end the same is seen, I don't know.
Yes, my lord. Court audio is like that only. Court
Not only
video.
audio, for me, video is also
Video, yes.
possible.
Court video, my lord. Other camera is not working properly.
Not working properly. It is distracting.
Yes,
Some
Yes,
green
my lord.
color
And
is
it is-
also coming.
Yes, and it is causing lot of eye strain for us.
That is why I switched off. I myself did that.
Yes, sir. Please, sir.
ಯಾವಾಗ ತಗೊಳ್ಳಿ ಆಯ್ತು ಯಾವಾಗ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ Mr. Krishnaswamy, how much time you require? You got the paper? 3. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ ಆಯ್ತು 3. ಆಯ್ತು ನೀವು ಅಂದ್ರೆ ಗೆಟ್ ರೆಡಿ ಆನ್ ಆಲ್ ಆಸ್ಪೆಕ್ಟ್ ಸೈಟೇಷನ್ಸ್ ಏನಾಗುತ್ತೆ ನೆಕ್ಸ್ಟ್
86 M Balaji.
A. Balaji, B.M. Mohan Kumar. A. Sanmati, H.T. Jagdish. Kudi. Petition is dismissed. Learned counsel to the appellant is absent. No representation. Appeal dismissed for non-prosecution. ನಿಯರೆಸ್ಟ್ ಡೇಟ್ ಕೊಡಿ.
ಲಾಸ್ಟ್ ವೀಕ್ 11 ನಾಳೆ ನಾಡಿದ್ದು ಹಾಗೆ ಬರ್ತಾರೆ.
ಅದೇ ಹಾಗೆ ಆಯ್ತಾ? ಓಕೆ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಏನಾಯ್ತು ಮೇಡಮ್? ಅದು ಆಡಿಬಲ್ ಇರ್ಲಿಲ್ಲ ಅವಾಗ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 75.
ಸೀರಿಯಲ್ ನಂಬರ್ 75 ಅಂತ ನೋಡಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇವತ್ತು ರೀಚ್ ಆಗದಿರೋದೆಲ್ಲ ಯಾವತ್ತು ಬರುತ್ತೆ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಸರ್, 24th.
ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ 72 13 ಏನಾಯ್ತು ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್ 32 17 630